Welcome to my world. Come on in and make yourselves at home. Welcome to my life. I know everything's gonna be all right. Welcome to my world. Oh, won't you come on in? Welcome to my life. It's known as the Tiger's Den. Greetings to all of my subscribers. I want to thank you for being with me for as long as you have, and the new subscribers that's coming on in. We want to say greetings and thank you for your time. This is from Toothless and the moderators. Welcome to the Tiger's Den. This is the voice of Cheryl, and I am Toothless Tiger, bringing to you a true story. Hello to those that are in the bushes and the trees and the mountains and Belize, on the beach, on a cruise, in the sky, wherever you may fly. Welcome, and thank you for coming by. We're going to talk about what's been going on with this trial, I believe. And I don't believe it's just this trial. I believe it's going on all across America. I think because all eyes have been in Georgia since Bonnie Willis decided to go after Donald Trump, then it's kind of been the focal point. And if you're paying attention to that case, which we know is now just halted, and with the announcement today that they're not going to take oral arguments until December the 5th, which is approximately a month after the election. So all of the trains that she said was steady rolling, they're rolling right into a wreck. And it's really unfortunate and sad. But it is what it is. And I'm sorry I'm making this noise. So just give me a moment. But it is truly a train wreck. I'd like to ask any of you, if you've never followed me on IG, if you would go and follow me on IG. I've been putting out a lot of little clips, and I've been getting some good feedback, so I appreciate that. A lot of people watch them. They don't too much comment or like, but you know, it is what it is. One thing about these social media platforms is it used to be driven by the numbers, but I'm beginning to think that everybody got a bite of the Orca well, and that's why my thumbnail looks the way it looks, because all streams lead back to Orca, and that's in any city or any state. What Orca is billions of dollars that the government gave to states and for them to fulfill their obligations after the C-19 situation. And so a lot of people are taking advantage of what happened during that time, just like people don't want to work anymore. But it's kind of hard to go back to work when, number one, you didn't do much working anyway, and number two, just to stay at home, they gave you double, some people triple, what you would have received in unemployment and food stamps. And then they gave you allowances for your rent. So it's kind of hard for people to get back in the swing of maybe a routine they never had. Or for those who had a routine, maybe it was a struggle, and you got to see for the first time in your life what it was like not to struggle. And then for the most of us, we're still struggling. And we had to struggle through that period because we didn't qualify for any of the programs. So I believe all the money is what the issue is. Has nothing to do with the crimes. It has nothing to do with the gangs. It has to do with Orca. the well. The well of money that's on the table. So I just kind of looked up Fulton leaders brainstorm about the Orca. And so let me start with that. And of course, I went to Google. And so I put in Fulton County. How much did they receive? Fulton leaders brainstormed. The funds allocated were just as large. The county used $75 million of the $200 million in Federal American Rescue Plan Act monies it received in 2021 for pandemic-related programs to eliminate the case backlog. They must be spent by December 31st, 2024. That's a good date to keep in mind because we're, fastly approaching December 31st, 2024. What better way to spend the money than to have all these RICO cases going simultaneously? Now, the $75 million went to the judiciary, period. And so it went to 4 of those individuals that I have in the thumbnail, which is the clerk of records. It went to the sheriff. It went to the judiciary, which are the court systems. And then it went to the DA. So those are the 4, they call themselves constitutional officers, that goes to the commissioners. And then I have the leader of the commissioners picture there, Mr. Pitts. They go to the board of commissioners and ask for money based on line item needs. Like they said, the backlog of all the cases. But yet we still know that there are people sitting in Fulton County Jail that's been there 2 years and longer. One young man been there 5 years and has not seen a judge, and had an opportunity to see a judge last week, and unfortunately she set it back to, I believe it's September or October of this year. So still, he has not seen a judge in 5 years and 9 to 10 months. But this article says Fulton County weaponized the Orca funds. So let's see what it says here at the top. Now, it seems like they have problems throughout the state of Georgia, and some serious problems. And all of this is going to take us back to the trial. But in my profession, I'm taught to follow the money. And if you follow the money, then you can find the corruption at the end of the rainbow, that pot of gold that they speak of. It says Fulton County's Project Orca recently recruited 2 Cobb County senior judges, the Honorable G. Grant Brantley and the Honorable Adele P. Grubbs, allegedly to assist in managing the Fulton County Superior Court backlog of cases. The timing of the recruitment and their resulting rulings leave little to conjecture. Cobb senior judges are being used as mere cover fire for the improprieties of Fulton judges. And we see the improprieties of Fulton judges. We finally got Judge, I called him as Bay in my chat, called him Judge Biasville. We know him as Glanville, but he's been so biased, and so we call him Biasville. This article comes as an unanticipated 5th part In a series of articles following an array of retaliatory actions of the Fulton County judiciary and law enforcement against a man not backing down to the system. Power versus truth. And this is a young man, and he was on Miss Bumpus's page, and he was saying to look up the Orca, but I've been talking about Orca in all of my videos ever since I heard it when Ashley Merchant went before the state Senate committee, and I found out that these people, let's take Fonnie Willis, has a $36.6 million line item budget. She goes to the commissioners and tell them she needs to hire at least 50 DAs and clerks and things of that nature in order to get the backlog and the attorneys that she need to work the first appearance hearings and the taint appearances. And if well, the taint is not an appearance, it's where they actually are supposed to be redacting information that's not needed to go to the DA. So when I heard the monies that she received, and then once she was approved for the monies, she didn't spend them. The only 3 attorneys we know that she purchased was Nathan Wade and the other 2, the man with the name like her father, which I still believe that's hanky panky. We never ever, Ashley never got his invoices, but he has the same name as her father, so that's kind of weird to me. And her father was also involved in the teacher's RICO case. But this man is supposed to be the RICO guru. But she hired someone who's never tried a felony case as the special prosecutor in charge. And then she hired another lady, and her name seems to just fade to my mind. This article comes as an unanticipated 5th part in a series of articles following an array of retaliatory actions of the Fulton County judiciary and law enforcement against a man not backing down on the system. Derrick Jackson, a resident of Fulton County, was robbed of his due process rights under the Constitution just days before Christmas of 2022 by Fulton County Superior Court Judge Melanie Leffridge. After Jackson took to media about the situation, his family was thrown out of their home located in the country club of the South by the Fulton County Sheriff's Scorpion Unit without a proper court order. Project Orca. So I looked at one of the commissioners' meeting, and Fonnie Willis was there asking for money. And she never told them in any of her line items that she was going to hire Nathan Wade as a special prosecutor. And she didn't even have to give his name. She just didn't even tell that she was going to hire a special prosecutor, period. And so when they gave her the money, they asked her, I heard her ask about the name Orca, and someone mentioned that, and she said she didn't know what it was until somebody told her that it's so big that they named it after the whale, Orca. But they're using that Orca money, in my opinion, to launder and live a life of Riley while the people of the county are suffering. When she goes on the trail to get the European votes and to justify money's coming in from all over the United States, which is very hard to believe that people all over the United States would be sending her money, especially people in Iowa and Utah and Montana, places like that. It's just kind of hard to believe that's going on, but that's where a lot of her donations came from, supposedly. Act Blue. But it's very hard to believe that this woman is serious about anything other than where is the money and let me have it. Because we still have men and women in Fulton County that are being unalived as we speak. most recent being April, the beginning of April 2024. And so when it's not your loved one, then I guess it doesn't feel that bad, or it's not really that important. But these things are very important, and injustice to one of us is actually injustice to all of us. And I know many people really don't want to hear this type of content, and neither does, I believe, YouTube want us to even discuss the things that happen to us as Asiatic people. That has happened. We've listened to everybody tell our story, but we won't even have the conversation because we're so engaged in entertainment. And as Silent Weapons reminded us, keep the adults' entertainment at a 6th grade level. And we're always busy doing something. We're working, we're running, we're whatever it is that we do. We're always so busy till we don't really have a chance to comprehend what's really happening to us. We don't even have the forethought to know that it's so much that we don't know and we haven't been taught. So we look at things through the lens in which we have knowledge. And a lot of our knowledge is very limited. No matter who we are, because we're going to be geared to the wrong place. I don't practice law. I don't give legal advice. I'm not an attorney nor a lawyer. But one thing I've learned over the years is what law school does for them is teach them where to go. They don't have to hold all this knowledge in their head. Although after you do something over and over again, repetition strengthens and confirms. Faith comes naturally. So eventually some of this stuff is going to stick with you, and you're going to know it like you know your name and your birthday. Some of us even know our social security numbers and our driver's license numbers and our phone numbers. In the day of information, we kind of forget all that because we leave everything up to the computer now. So there's a lot of things that we choose as humans not to do anymore until we're replaced with robots, and that's happening every day too. That's another story. But let's go on with the Orca story because it's very interesting. On June 30th, 2021, during a Fulton County Board of Commissioners meeting with the county's mayor, at the height of the C-19 pandemic, County Manager Dick Anderson and Fulton's court case backlog had gotten out of control. Fulton leaders brainstormed. Just over 5 months later, when Fulton's County finally reopened, county leaders embarked on a path to address the backlog, which, after being inventoried, totaled 148,209 open and active cases. Fulton, the state's largest and most populous county, with Georgia's largest court case backlog, chose a name just as big for the strategy, Project Orca. The funds allocated were just as large. The county used $75 million of the $200 million in Federal American Rescue Plan Act monies it received in 2021 for pandemic-related programs to eliminate the case backlog. They must be spent by December 31st, 2024. That's why they don't want to let this case go. Judge Krauses did a very lousy job, and all she did was protected the money. Some would say she protected her friend, her colleague. You can call it what you like. I just choose to call it that, and that's my opinion. Nobody has told me that, but I have the ability to read and reason, and everything in law is about a reasonable person's point of view. So using a reasonable person's point of view, I would surmise the way she wrote that paper, actually exonerating the DA office and the judge of any wrongdoing. She wrote that slap out of the paper, and the only thing that she could come up with is what Thurgood Marshall taught me. One day I was looking at a documentary on him, and what Thurgood Marshall said was the same law that they use to railroad you, to convict you, to do whatever it is that's done against you, you're going to have to use that same law to free you. And that's the truth of the matter. That's the law that's going to free you, the very one that they try to convict you with. But let's go back to Orca. For Fulton, Orca has been synonymous with solution. As of July 31st, about a year and a half after launching Project Orca, the county had disposed of 108,661 cases, becoming a model for justice systems across the state and the nation. Now, they said they disposed of. Do we know how they disposed of? Because we've seen in the Young Thug trial that the police officers say that they erase recordings and throw away records. So how did they dispose of these? Were the people processed through the system? Some went home, some went on to prison. How did they dispose of them? Or some languishing in jail, never being indicted, and never seeing a judge, and getting eaten by bedbugs. How did they dispose of it is my question. But anywho, who am I and what do I know? Fulton won one of the National Association of Counties Achievement Awards, and they love to give awards. Although we never see any results tangibly that we could put our hands on, or we don't know anybody that we could talk to who say that they went through this, as Love opening statement with Young Thug's trial, the jungle, and made it through to the other side. We didn't run into no lions, no tigers. We didn't run into any snakes, any monkeys. We didn't run into any of that. We just navigated like Tarzan through the trees, and we made it through the jungle to the other side. We haven't heard any of those stories. All of the stories I've heard, and I look at a lot of the commissioners' meetings, I look at the election board meetings now, and I even look at when their city people come together. And I can thank L.A. Pink for that, because she's out on the front line. She and her organization, Street Groomers, fighting every day for people, the voice of the voiceless and the friend of the friendless. And so watching her do what she does makes me sit up and listen to these different meetings just to see how they're done. And citizens go and speak their voices, but they go on deaf ears. Okay, so in May, it won an Association County Commissioners of Georgia County of Excellence Award for the same reason, the case race. So how exactly does the Project Orca devour cases at such a rapid pace? What is the secret? Cobb County Attorney Matthew D. McMaster shared his opinion. The court's due diligence is our due process, and due diligence takes time. If time is being reduced, so is due diligence, and in turn, due process. It's as simple as that. When asked if there is evidence proving that due process rights were being sacrificed at the hand of Project Orca, McMaster responded, absolutely. The numbers don't lie. And that's one of the things that we know is true. 2 + 2 = 4 everywhere in the world, no matter where you are in the world. Well, unless you own some other stuff, and I'm not into that. I don't know that kind of science or that kind of mathematics. I just know the one that they taught me. And 2 + 2 = 4. Okay. To his point, looking at the numbers, disposing of over 100,000 cases in a year and a half. I have to go to the other page because my little mark is there and I can't see what that is. So let me get over here. Leaves little time for due process. Project Orca keeps a public scorecard of the number of cases closed by a judge. And they got footnotes. While best intentions may be behind keeping score in this manner, the end result is that judges are incentivized to cut corners, sacrificing due process simply to keep their case numbers down, contributing to the atrocity Fulton was nationally recognized for its innovative methods of whittling down the backlog. It is clear here that, as with communism, misplaced incentives result in misbehavior, namely abuse of power and deprivation of rights. And we can see that with so many people being still in a jail that they're trying to get rebuilt for billions of dollars for a jail that's it's actually pre-prison. Who would go and build a $1 billion facility just to transport people to a penitentiary where they're going to stay for pretty much, some of them, for the rest of their lives? Makes no sense, but it does to them, they say. I think it's all behind Orca. On April 2nd, 2023, Navigating Justice published an article entitled, "Georgia Ethics Code Does Not Apply to Fulton Judges." We know that's right because of what Glanville did. He decided, even after reading the Judicial Conduct Code 2.9, that he wasn't supposed to make the decision on the recusal at the stage in which they asked him in writing. But he said no, he'll do it, and y'all can take it up on appeal. And that's his main response to everything that he was allowing to go on. I know that they're doing what they want to do, but take it up on appeal, knowing that that could cost these young men years of their lives. And different family events have taken place since they've been incarcerated without bond. Mrs. Stilwell lost his mom to whatever her illness could have been. But it's just sad that these are the type of things you have to go through, and you haven't been convicted of anything, and the presumption of all Americans is supposed to be that you're innocent until proven guilty. Okay. So, discussing the Fulton County Judiciary's refusal to recuse Judge Melanie Lethbridge from presiding over multiple cases where Judge Lethbridge showed clear bias, conflicts of interest, and plain incompetence. Here's a brief excerpt from that article. And you know, that's one of the reasons that Judge Peterson was actually removed for incompetence, as well as an ex parte conversation. The courthouse shell game. There are two ways a judge can be recused or removed from a case. Number one, voluntarily. Number two, involuntarily. The latter, at least in Fulton County, occurs amongst flying pigs and unicorns, meaning it generally don't happen. Jackson's case has extracted that fact pretty clearly. On March 23, 2023, Derrick Jackson filed a petition for writ of mandamus and writ of prohibition demanding, among other things, the recusal of the entire Fulton County Superior Court bench after two of the judges, including Judge Lethbridge, failed to recuse themselves from the eviction case despite conflicts. Two judges, one in the eviction case and one in the quiet title case, refused to recuse Judge Lethbridge, and three judges, including Judge Lethbridge, all refused to appoint a special master whose appointment is mandated by Georgia law in the quiet title case. So you can see Thug and Trump are not the only two cases, as well as the school teachers, I can never forget them, of people that are being messed over. Just imagine how many people are being messed over for the name of Orca. And the money is not going to the people, it's going to the people that's in charge of the money. While Judge Melanie Lethbridge has refused to recuse herself from the Jackson cases, she has since failed to appear at any hearings or rule on any motions in connection to those cases. Rather, Judge Lethbridge appears to be hiding behind Project Orca in avoidance of her duties. To that end, Cobb County senior judges Adelie Grubbs and Grant Brantley were recruited by Project Orca to execute Judge Lethbridge's duties. So now somebody else got to do her duties while she's getting paid her salary as well as the money that was additionally budgeted to her through the Orca grant. Unlike Lethbridge, these senior judges are appointed to their roles and are not subject to election or re-election by voters. As the date of this article, Judge Lethbridge still remains the assigned judge according to the Fulton County Clerk's Office. There are certain things we just can't get away with as citizens. We just can't do it. And if we don't hold these people accountable, then they get to do exactly what they do to us. A lot of the things they do to us is out of our fear of retribution, but we're already being attacked. So we can't be afraid. We have to get into these articles of incorporation, which is the Constitution of the United States. We have to learn the Bill of Rights, which are the first 10 amendments, and then go ahead and go up to the 14th Amendment, due process. And we have to know what they say. We don't have to memorize them. We just need to have them and know what they say and hold them to that. They also have a department where you can make actual complaints. Let me just drop that in the chat right quick. On judges and attorneys. And you can make as many complaints as you want. And maybe nobody will listen to your complaint. But you never know if you don't complain. You'll never know. Most of the time they have us in fear. And don't think that, you're in fear alone. We all have fear. That's a part of being human. But it's called feel the fear and do it anyway. All right, Asator, Phyllis, and Regina, glad you guys made it. But here we go. I just dropped that link in there. Cobb leaders rest on their laurels. Let me make sure I read that. Yeah. So why would Cobb County senior judges be complicit with Fulton County's agenda? Some surface level research reveals that the start and end of the analysis lies with their personal incentives, time and money. And you see the different footnotes. The Honorable Adele P. Grubbs, born in December of 1944, earned her law degree from Manchester University in England before she moved to the U.S. state of Georgia in 1969. Grubb was the first woman assistant district attorney in Cobb County and was elected to the county's Superior Court in 2000. She retired after the end of 2016 term and was appointed as a senior judge in 2017. The Honorable Grant Brantley was born in Georgia and grew up in Griffin. Brantley graduated from Emory Law School in 1964 before joining the Air Force as a judge advocate. He moved to Cobb County after his military stint and served in a variety of government positions, including Cobb County Superior Court judge from 1980 to 1992. He didn't seek re-election in 1992 because he was in the process of being nominated to the U.S. District Court by President George H.W. Bush. But the 1992 election spoiled his call-up to the federal bench. Judge Brantley was appointed as a senior judge in 2007. Follow the money. And remember, I told you that's what my occupation taught me. It is clear from above that both Judge Grubbs and Judge Brantley had very prominent legal careers and were highly regarded assets to the Cobb County justice system. However, at some point in their golden years, in their retirement tenures as senior judges, they appear to have wavered and fallen from foundations built on principles only to compromise their respective legacies. But for what? The most obvious answer reigns supreme: money. Understanding how judges are paid sheds more light on the matter than is palatable. So, let's look at it. I want to welcome everybody and thank you and remind you, if you like this content, please hit the like button. I'd greatly appreciate it. And subscribe to the channel. Even consider becoming a member. I have memberships as little as a cup of coffee. $1.99, $2.99, $99, $3.99. I believe $4.99, $9.99, and $24.99. Full-time annual salary, elected judges. Full-time Superior Court judgeships in the state of Georgia are salaried positions that are paid with state tax dollars and oftentimes subsidized by the county in which they preside. In Cobb County, for example, Superior Court judges have salaries paid for by both state and county taxpayers totaling around $200,000 annually. For their pay, these elected officials work full-time presiding over matters within their respective jurisdictions. Elected judges serve for 4-year terms and must be re-elected by a majority of the voters within their county if they wish to remain on the bench. Thus, their job depends on the voters and, in turn, campaign donations. The end result: full-time elected Superior Court judges cater to their campaign donors. In other words, campaign donors and political supporters get preferential treatment and favorable results in cases regardless of the actual facts. And that's true throughout the whole America. The following chart illustrates how campaign donations influence a full-time judge's decision. Campaign donations, voters, taxpayers, elected judges. So the donations is 1 and 2. The voters and the taxpayers 3 and 4. The judge is in the center. As shown above, 1. Campaign donors contribute money to an elected judge's campaign. 2. Campaign donors then gain influence over the elected judge's decision, and in turn, the judge caters to the desires of his or her donors. Number 3, the elected judges use his or her campaign funds to influence the voters, increasing the likelihood of keeping his or her job in an election. Number 4, taxpayer money funds the salary of the elected judge, though the taxpayer do not have influence over a judge's decisions because taxes are mandated by the government, and the tax-paid salary is not the result of a judge's performance on the bench. Part-time daily pay senior judges. Part-time senior judges in the state of Georgia are paid by the state a daily rate in the amount of the annual state salary of a judge of the applicable court divided by 235. So based on $200,000 estimated Cobb County annual salary for elected judges, a senior judge presiding in Cobb County makes about $850 per day. These senior judges obtain their respective working days by having cases assigned to them by full-time judges. Mediator assignments are also court-appointed roles that senior judges receive from full-time judges. And when a senior judge serves as a mediator, he or she makes their money at a premium hourly rate, usually between $150 and $350 per hour. In short, a senior judge's job heavily depends on the will of the full-time judges. The end result, part-time senior judges cater to the desires of the assigning full-time elected judges. Thus, if a full-time judge wants a specific outcome in a case, the part-time senior judge will make it so, simply to increase his or her opportunity for future appointments by the particular full-time judge. So now we haven't even gotten to the person that may need the law one way or the other, for them or against them. We haven't even gotten to that person yet. This is just the politics of the office. The big picture. In an article published in 2022, Cobb County State Court Judge Carl Bowers said that when Bowers went into private practice, Brantley told him to remember he was not just practicing law, but running a business. Interestingly, while a judge is a government position for the purpose of serving the public, Judge Brantley treats his judgeship exactly as a business and nothing more. The below chart illustrates how the business of a superior court judge is concluded. 1. Campaign donors. 2. And it goes to the elected judge. 3. Voters. 4. Taxpayers. And then you come on down. And I'm going to go over here to 8. Mediation. Assign litigating parties. Plaintiff, defendant. Number 5, coming on down. Case assignment. Okay. Now, if you look at litigating parties and plaintiff defendant, you will see number 10, it all goes down under mediator. And then voters and taxpayers, number 6, goes down to senior judge. And then elected judge, 7 and 11. It's like shooting dice. Elected judge. Number 1, campaign donors contribute money to an elected judge's campaign. Number 2, campaign donors, by virtue of their donations, gain influence over the elected judge's decisions, and in turn, the judge caters to the desires of his or her donors. And that's one of the things that I stress to the people, is if we don't fund the people that we put in office, then our agenda is never going to be addressed, because they're going to cater to the ones that feed them. Number 3, the elected judge then uses his or her campaign funds to influence the voters, and the judge is therefore able to increase the likelihood of keeping his or her job in an election. Although they'll spend their money telling us that they're going to use money to help us, that rarely happens. Number 4, taxpayer money funds the salary of the elected judge. Though the taxpayers do not have influence over a judge's decision, because taxes are mandated by the government and the tax-paid salary is not the result of a judge's performance on the bench. Senior judge. Number 5, the elected judge assigns a case to a senior judge. Number 6, the senior judge is compensated with tax dollars at a daily rate in the amount of the annual slate salary of a judge of the applicable court, divided by 235. Though the taxpayers do not have influence over a senior judge's decisions, because taxes are mandated by the government, and the tax-paid salary is not the result of a judge's performance on the bench. Number 7, the elected judge uses this case assignment power to influence the senior judge, and the senior judge, in turn, caters to the desires of the elected judge in order to increase the likelihood of being assigned to cases in the future. Mediator. Number 8, the elected judge assigns a case to a mediator, who is oftentimes also a campaign donor and or a senior judge. Number 9, the parties in the case are ordered to mediation for the purpose of trying to settle the case. Number 10, the parties are ordered to pay the mediator at an hourly rate, usually between $150 and $350 per hour. Number 11, the elected judges uses the mediator assignment power to influence the senior judge, and the senior judge in turn caters to the desires of the elected judge in order to increase the likelihood of being assigned as a mediator in the future. So it goes back to that old saying that they say in politics, one hand washes the other. You wash my back, I'll wash yours. And then it says you can also look up Cobb County judicial misconduct, a participant in Cobb's notorious pay-to-play way. Short-sighted swan song. It appears that heavily distinguished and once well-respected Cobb County judges have in retirement abandoned their principles and are enabling injustice at the expense of their good names. And what exactly changed, if anything, that transformed these once highly regarded judicial leaders into mere henchmen of the establishment? The most obvious answer prevails: how these judges make their money. And that's Deborah Brockman, Navigating Justice. And then she goes on to say, if you are aware of any similar problems in Georgia legal system, send the details and the documents here. And then they give you all the references and footnotes. So you could just look that up on Google like I did, because that's what I did. I wanted to know more about Orca. I hadn't read the article. I just looked up this and copied the search page. And I wanted to know about Fulton County and how they claim that they are hiring people to reduce all of this backlog and stuff like that, but we don't know of anything that they've done other than hired the people to help in the Nathan Wade case. Even the experts that they had in Young Thug case were retired police officers, and I believe they were retired by force, not by choice, and they're now working in other companies, but they had no reports. They couldn't remember anything. And then as we watch the trial unfold on YouTube and television, we get to see that they're getting all of their investigative information from one source, one man that Love said that was a building block to the rest of their case. And so everything had to be based off of his story and his testimony, and that's why they forced him into use immunity, saying like they gave him a great out, but really they did not. They're not protecting him from any protections of anything that they find independently or somebody would engage him in, and he's getting to tell all that he's done, ruining his reputation or whatever beliefs anybody may have had in him. But he seems to be having a good time going around on YouTube, and he has a channel, and that's good if he can make money, because everybody else is making money off of his name. So I don't begrudge him of that, but I hope that he's getting some help emotionally and with what's going on with his trauma from then and now, because two of the judges that's involved in this case have been judges that he has stood before. Judge Krauses, who made this decision, so to me her decision is biased, just like Judge Biasville, because she wrote everything out, all misconduct, and we're going to talk about that. In 2022, it says Fulton County adopts $1.25 billion budget. Let me see this article here. Some of these, a lot of them, they want you to subscribe to their paper. And everybody faces challenges in Fulton County. I did Instagram post about another illegal meeting that was held last week on July 12th by the Fulton County Elections Board. And remember, these are the same people that are supposed to be after Donald Trump. So I thought that was strange. Let me take this down because it's okay. So it's not giving me what I want. Let me take that down and see if I can figure this out. This is the kind of money. So this is why they going on and on with these cases. It has nothing to do with justice and right. And that's how they can do what they do and don't care. Because they know what they're profiting and what they're benefiting. Fulton County adopts a $1.25 billion. This was January 25th, 2022. Fulton County, Georgia. Fulton County Commissioners passed a $1.25 billion budget for 2022 that takes special aim to fund elections, stress employee retention, and address backlogs in the judicial system. The 5-2 vote on the January 19th Commission meeting also provides funding for continued C-19 emergency responses. The 2022 budget includes a 6% increase for the county's general fund to approximately $847 million. The general fund pays for the day-to-day operation of the county and its services. It includes employee salaries and building maintenance. Commissioners Bob Ellis and Lee Morris cast dissenting votes. The Registration and Elections Department is slated to receive $37.4 million, the majority to fund administration and operations, and the remaining $2 million earmarked for registration and absentee voting. County employees are awarded a 7% cost of living pay raise. The measure was introduced at a December 15th meeting by Chairman Rob Pitts, who said Fulton County needs to take care of its employees. And boy, are they taking care of their employees. And then these documents like this is documents you can look into. The budget also aims to tackle backlogs in the justice system through funding a multi-year backlog reduction program called Project Orca. The county has pledged a total of $75 million in federal recovery assistance toward the program. Project Orca includes every department in the justice system, from district attorney to the sheriff's office, and pledges more than 300 additional positions over 2 years to help reduce existing backlog. Now, these are the things that Ashley Merchant asked for in the Freedom of Information Act, and the DA's office said that they do not keep those records. There is no way you hire individuals and you don't have a record of their hiring, because how do you pay them? That just doesn't work. The county budget also sets aside $16.4 million in reserve for emergency response, which has been earmarked for unforeseen events associated with the C-19 emergency. This funding will work in tandem with any federal, state, or grant money the county receives to address the pandemic. And trust me, the county receives a lot of grant money because Fonnie Minnis got an additional $2 million for, the Kids for SA backlog that she hasn't spent much money on. The budget also includes a roughly $6.8 million reserve with earmarked projects that will be discussed and potentially funded before or during a planned mid-year review of the budget, commissioners said at the January 19 meeting. So then there's money. They can't even tell you how it's accounted for. And they're not even trying to tell you how it's accounted for, which is amazing, in my opinion. I want to take that down. I don't know if I done messed up something or not. I don't want to take that down. Let me pull this up and see if this is still there. Yeah, so what I've come up to is we're going to look at this Judge Krauses. Everybody has read it, so you may have heard it in somebody else's chat. Well, I'm just going to give my take on it. I hadn't read it before. I was kind of going through Brian Steele's document and showing the videos that he purposely put in there so this lady can see the judicial misconduct, but she wrote all of that out. Hey, Regina, let me see. I heard that Fulton County decided to not build a new jail to help elevate the overcrowded jails now. Instead, they have decided to renovate. Yeah, that is what they did. But what the problem is with that, and see, that's a lot deeper than what we know because of the, they wanted Cop City. And the people are not backing Cop City. And that's why they're talking about this $1 billion facility that they want, that the people cannot see it, because what they have come to know, the problem with their jail system, it is older jail, but it's not so old that it can't be repaired, and it should have never gotten in this condition. The problem is management. That's what they know is true. The sheriff purchased himself a $200,000 Mercedes-Benz Sprinter truck. And, I just don't know the need for the sheriff to have that. But that's what he purchased for himself. But let's go with this judge so we can see how she, as the judge would say, surreptitiously gutted his motion and actually just wrote a lot of jibber jabber for the public, because that's what this is all about. It has nothing to do with justice. Nothing at all. I agree, the problem is management and mismanaged funds. Yes, exactly. Okay, we're not going to read the header so much as the people and stuff. We can see that. That's all of the 6 defendants that's in court right now that's going through this nightmare that's taking place. Okay, she got order on motions to recuse Judge Glanville. This case is before the court to consider various motions to recuse, including, and he had given her in April of this year $2,000 donation, which they said that is a lot for someone to donate another judge to a judge, but it didn't meet the standard of too much, which the limit is like $8,000, $8,400, I believe. But he only gave $2,000, which is way above the norm of what people donate. But he did that in April. Now, he ran unopposed, and she had one, so he didn't feel that was enough to cause her not to be able to make the right decision, and it should not be, but she didn't make the right decision. She gave the people, the sheeple, the sleep ones, what they wanted, and that was to have him recused. But she did it in such a way that she wasn't as honorable as the judge in Alec Baldwin's case, where she could cite judicial and prosecutorial misconduct and dismiss the case with prejudice. No, no, no. She didn't do that. She took away all of those type of behaviors and just stood on the strength of what he should have stood on, what the law requires for him to recuse himself. But she did on Mr. DeMonte Kendrick's motion, Mr. Jeffrey Williams' motion, and Ms. Kayla Bompa's motion. The specific facts necessary to determine these recusal motions are well documented in affidavits, which she thought they as being jokes, because she so much as said so about Mr. Steele's. Court filing, certified transcripts, and video recordings available on YouTube. Having considered the record evidence and applicable case law, the court finds as follows. And I'm not going to read the footnotes because she just wanted to, again, show the people, the sheeple, whoever, that she did the right thing, but she didn't do the right thing. She did the thing. That's what she did. Hey, Kelly G, good to see you. These recusal motions arise out of the multi-defendant prosecution brought by the Fulton County District Attorney's Office, alleging gang activity and associated crimes. Kendrick, DKT 4. Although there were 28 defendants named in the indictment, only 6 were being tried as of June 7, 2024. The motions to recuse all arise from the same circumstances related to the state's witness, Kenneth Copeland. On June 7, 2024, the state intended to call Kenneth Copeland to testify. Prior to his testimony, counsel for Mr. Copeland, Jonathan Melnick, appeared and indicated in open court that Mr. Copeland did not wish to testify and intended to invoke his Fifth Amendment privilege against self-incrimination. Judge Glanville brought Mr. Copeland into the court and discussed with him the effect of an immunity order Judge Glanville had entered that granted immunity to Mr. Copeland. Well, to me, Judge Glanville was out of order. She knows he was out of order because he offered that immunity that morning. It is not like the state had been offering him immunity the whole time. They offered the immunity and they didn't offer it, they forced it. When Mr. Melnick sent them an email on June 6th to let them know, stop talking to my client, because he does have an attorney. Then they went to the judge, and I believe they emailed him that evening, and then that morning before court, they went and had him to sign that order. But if you look at them in the courtroom, it's not abundantly clear that he signed it until after all of this had taken place. Now, Mr. Steele had put all of these in his motion. He put all of the YouTube videos, and I had 1 or 2 of them up here, but I guess I took them down. Let me see. This could be one. I don't know. This is one. I don't know if it's the one that I wanted, though. Let's see. I don't think it is. So let me go over here. Yeah, I'll be having this stuff all set up, and I'll be so ready. And I always hit something and make it all messed up. So, y'all know how I do it. Y'all just gotta forgive me. I'm gonna get it together one day, and I'm gonna know what the world I'm doing. One day, I don't know when. Okay, I think it's this one here. It's the one I want. Yeah, this is the one I had. Okay, and so let me see. Where did I write it down? I thought I had a fresh piece of paper. Maybe I didn't. Let me just go back here. Because what I want y'all to just see how this played out. And this lady, she didn't address any of this stuff. All she addressed was the ex parte hearing, saying that it was acceptable. 112:50. Okay. Okay, let's go here. Okay, I want y'all to listen to what Mr. Melnick has to say.
Issue regarding whether Mr. Copeland will testify at this trial. I am representing Mr. Copeland. Your Honor, I spoke with several individuals in the Fulton County District Attorney's Office before this case was indicted. And the Fulton DA's office was very well aware that I was representing Mr. Copeland. Apparently, they have had conversations with Mr. Copeland outside of my knowledge and presence. Now, I can't do anything about that because he talked to them without contacting me first. However, he did contact me yesterday and told me that he was being subpoenaed to testify here today. And I asked him what he wanted to do. His position had been and has always been that he wishes to exercise his Fifth Amendment privilege against self-incrimination. I have explained to him, and I learned this morning that apparently an immunity order has been entered under OCGA 24-5507, granting him use immunity for testimony at this trial. I would object to that proposition. And the reason is this. I know very well that the district attorney's office knew about my involvement in this case from the inception of this case. I spoke with Don Geary in 2021 about this matter. And he asked me whether or not Mr. Copeland intended to cooperate with the state. And what he told me is that Mr. Copeland would probably either be a witness or potentially a defendant in this case. I spoke with Mr. Copeland. We had numerous conversations between myself, Don Geary, and Thomas Greiner, who's in the Fulton County District Attorney's Office, who was prosecuting Mr. Copeland for a separate matter. And Mr. Copeland has steadfastly said that he intends to exercise his Fifth Amendment privilege. I have also participated in a conference call regarding a bond for Mr. Copeland when he was when he had an indictment in Judge Whitaker's division. Present in that conference call was myself, Adrian Love, Adam Abadi, Abby Potter, and Judge Whitaker. And we very specifically discussed the state's concerns about Mr. Copeland getting a bond in that case, given that the state wanted to utilize him as a witness in this YSL case. So, Your Honor, Mr. Copeland is here. I can state as his attorney that he intends to exercise his Fifth Amendment privilege against self-incrimination. He does not wish to testify in this trial. And I would ask, there is no other, he's not on bond, he's not on probation, there's nothing like that. I would ask that he be allowed to leave this courtroom without being compelled to testify.
All right. Ms. Hilton, do you wish to respond?
Yes, Your Honor.
Now, the judge and them already got together and talked this out. They had already got together when they came to him that morning and asked him to sign that document. Nothing is supposed to be able to circumvent or contravene your rights under the Constitution. Generally, when they offer immunity, and again, I'm not a lawyer, I don't give legal advice, but I have common sense, look at court shows and read so I comprehend a little bit. But when you have an attorney, your attorney is in on whatever it is that they're going to do. They don't just arbitrarily do that. It's once they found out that this man was still in the picture, they woke up, well, they contacted the judge that evening when he sent them that email. And they decided that they were going to give him use immunity that would force him to have to testify. And, you know, they love to say that only the DA can do it. And, yeah, we know. And the DA is Fonnie Willis. So, again, it all goes back, in my opinion, to the Orca money. Because Adrian Love is going to state that he's the linchpin to this case, and he is the building block, the foundation in which the house is going to be built on. So, let's move on along. I'll take it down so it don't make y'all dizzy. One moment.
Pass the good faith test of there's a lot of influences inside and outside. So I'm going to basically base it on the proffers of counsel and just remind you all of your professional responsibility requirements. Okay.
Well,
so I'm going to
remind it all the time because I've lived them. I'm just telling the court that in order for you to deny my motion for a this was bad.
And I'm going to deny your motion, and I've made my ruling. So I'm done at this point in time, okay? In terms of this motion for mistrial.
Well, I would like to call the witnesses, but I understand what you're saying.
I'm not going to call any witness. I don't need any witnesses. Your proffers are fine, okay?
Can I add a proffer now?
Yes.
As you know, we are in a side room off the hallway on the first floor. That's where defense counsel is kind of their conference room. During lunch, I'm working on unrelated matters, and I'm going to get a ginger ale to calm my upset stomach, and I'm on the phone, but I'm hearing a gentleman speak very loudly on the phone with agents from the state. It's my belief agents from the state were present within earshot. And that gentleman on the phone, who was Kenneth Copeland, was making it.
How do you know it was on the phone? If it was Kenneth Copeland's on the phone, was he talking on the phone or?
He's standing in the hallway 10 feet from me, practically screaming in the phone.
Oh, so Mr. Copeland's on the phone?
Yes.
Okay, and you're overhearing this particular
He's saying,
purported conversation.
I'm not testifying. I'm not giving a direct quote because I was on the phone handling my own business and I was having no interactions with.
Okay, but here's the thing. I think it's consistent with I'm not testifying. Okay, he can make a decision not to testify. Okay, but if he does so, and because he's already been told, look, you can invoke your Fifth Amendment privilege, and you've been given immunity, and if you don't, I told him what the consequences are this morning. That's consistent with what I've heard thus far, and I don't think that is.
I believe that the state was on notice that something like this was going to
Okay, all right, but all of you have kind of, like I said, either unwittingly or I just remind you, from outside agitation or otherwise, you all need to stay away from any of this. You do. Both sides need to do this. Do not let outside influences, influence your actions and get you in trouble. You all should rise to a higher standard in terms of don't let any of this stuff. I mean, these witnesses will testify to whatever they're going to testify to. So
The defense has done nothing.
I didn't say you did anything wrong. Okay, but I did.
I've heard is state.
I didn't say you did anything wrong, but
I understand,
okay.
Your Honor, but I just want to be clear. The only thing that I've heard today is that the state met with Kenneth Copeland without his attorney.
Are we going back to that again? I thought we.
I don't know of any counsel that's had any conversations with Kenneth Copeland at all, and I just want to make that clear. Today, I don't know of anyone that's had conversations with.
Okay, but he's their witness at this point in time. If he wants to talk to you or he doesn't want to talk to you, he's got a lawyer, and that lawyer can make that decision, and so can Mr. Copeland. So
Situation because
I understand that, but you can't let other people, and I would advise you not to let third parties influence what you may think a witness is going to do.
That's not happening.
Okay, and that's all I was trying to tell you. Okay.
Okay.
All right.
Judge, I would like to hear.
Yes, sir. What does he like to tell me, Mr. Melnick?
Judge, I went back and reviewed my communications with the Fulton County District Attorney's Office in relation to Kenneth Copeland. And I found communications as late as June 5th of last year, where the Fulton County District Attorney's Office had reached out to me about speaking to Mr. Copeland. Speaking to Mr. Copeland concerning this trial, not about any other case, speaking with Mr. Copeland about this trial. Neither of these attorneys, no attorney at this table has ever attempted to contact me about Mr. Copeland and about his willingness or desire to testify at this trial. They have put us in this position where at the last minute, I'm trying to advise him as best I can what I think is best for him. Had they exercised the slightest bit of professional conduct, we would not be sitting here having this conversation today. And unfortunately, for me to fully explain everything that's been going on, it would require me to reveal confidences that I'm not going to reveal.
Okay, so in open court, this man said this to the judge. The judge acted like he didn't hear nothing he said. He went along with his ruling, and he's going to make it a matter of record. So let's just go on with the way this lady saw all of this in the motion that Mr. Steele found, but she left all of this out. She said, Judge Glanville specifically advised Mr. Copeland that if he invoked the Fifth Amendment and refused to testify, the state would ask for Copeland to be held in contempt and jailed. Judge Glanville also advised that if asked, Judge Glanville would jail Mr. Copeland for refusing to testify. Now, Judge Glanville already knew he was going to do that, but he said he probably. So here you have the judge lying on the stand, and he's telling them about not listening to outside influences and getting themselves in trouble, and how they're held to a higher standard, as if he's not. After that discussion, Mr. Copeland spoke to his attorney and then indicated he would testify. Once called, Mr. Copeland was asked to specify his age, and instead of answering, he stated, "I plead the fifth." Well, she left out three things because she asked him three different ways. He gave three different answers. The last one was, "I plead the fifth." So it's like they all were in cahoots. And certainly they got together and decided how she was going to write this up. Judge Glanville excused the jury and then advised Mr. Copeland in open court that he was in contempt and ordered him jailed until Monday, June 10th. At which time, Judge Glanville told Mr. Copeland they would revisit Mr. Copeland's willingness to testify. Mr. Melnick spoke to Mr. Copeland and then reiterated to the court that Mr. Copeland still intended to invoke his Fifth Amendment right if called as a witness. Judge Glanville indicated he would revisit the issue with Mr. Copeland on Monday, June 10, 2024 at 8:30 a.m. and court was adjourned for the day. What she neglected to say is he said he would do that in open court before he brought in the jury. But they didn't do that. On June 10, 2024 at approximately 9:10 a.m., Judge Glanville met with the counsel for the state, Adrian Love, and stand-in counsel for Mr. Copeland, Kayla Bumpus. The meeting took place in Judge Glanville's chambers. Counsel for the trial defendants did not participate in the meeting and was not aware that the meeting was taking place. The transcript reflects that Ms. Love told Judge Glanville that she wanted the meeting to vote and press upon Mr. Copeland the risk of refusing to testify and allow Mr. Copeland to ask questions before he testified. That lie changed because it was at first he was afraid for his life. And she said that in open court, that he sent, Mr. Melnick sent her an email saying F you because Mr. Copeland's life was in danger. So they just switched this whole story and found them a new way that she could write this without putting in their prosecutorial and judicial misconduct. Okay. So Ms. Love also expressed concerns to Judge Glanville about Mr. Copeland's representation. Ms. Bumpus, Ms. Love, and Judge Glanville also discussed the scope and effect of state's grant of immunity to Mr. Copeland. Mr. Copeland was then brought to Judge Glanville chambers where he spoke with and asked questions of Ms. Bumpus, Judge Glanville, and Simone Hilton. So now we done switch DAs. And she didn't say that Miss Love is no longer in the meeting, which she's not, because something happened with Miss Love and her representing his brother. So he doesn't like her, and she doesn't like him. So they don't even show the division. They just show now Simone Hilton is in there, who, by the way, they said was down there talking to him while they was up there talking, knowing he had an attorney, but his attorney was up there with them. That's not mentioned either. Counsel for state who had joined the meeting. During that time, the state advised Mr. Copeland that he could remain in custody until the conclusion of the trials of all defendants in the case, not just the 6 currently on trial. Judge Glanville discussed OCGA 245507 with Mr. Copeland and his rights and responsibilities after a grant of immunity. Mr. Copeland spoke privately with his stand-in counsel, Ms. Bumpus, and then advised the court that he would testify. Privately, he's talking about in a room with about 12 people, but he was over talking to his client, and even in the transcripts, it went on to tell them to talk a little lower because the judge could hear him. So how is that private? And then she goes on to say, after the meeting and immediately before Mr. Copeland was brought out to testify, Defendant Williams' lawyer, Brian Steele, advised the court that he was aware of the in-chambers meeting that morning. Mr. Steele objected to the ex parte meeting, and a lengthy colloquy occurred between Mr. Steele and Judge Glanville, in which Judge Glanville inquired how Mr. Steele became aware of the Chamber's meeting. And see, she even lied about that, because Mr. Steele told them from the beginning that morning. He asked him, and he didn't say anything about all of that he had found out. He just asked the question, and the man went on and brought the guy out. Then when they went to lunch and came back, that's when Mr. Steele said something, because he was just inquiring what happened that morning. They were supposed to be there early that morning at 8:30. But, the judge, the witness, the state, several of the people in the courtroom, and investigators from the DA's office were not there. Just the defense and the people that showed up to court to witness it, and the cameraman. So she left out quite a bit right there. And I think that's really sad that she was able to get away with this. So she said Mr. Steele declined to reveal the source of his information. Judge Glanville held him in contempt, though Mr. Steele was allowed to remain in the courtroom on behalf of his client, Defendant Williams. But at first he took him out and actually had him locked up. So she wasn't honest there. Ultimately, Kenneth Copeland did testify on June 10, 2024, and was later released from custody. Now, he locked up Mr. Steele and let Kenneth Copeland go because he purged himself of testifying. The next day, Judge Glanville issued a show cause order requiring everyone present at the ex parte meeting to appear and show cause as to why they should not be held in contempt for disclosing information about the ex parte meeting to defense counsel. And that's Kendrick DKT 245. An amended show cause order was later entered, setting June 1st, 2024 for an in-camera review of the transcript of the ex parte meeting. The first motion to recuse filed by DeMonte Kendrick on June 12, 2024. Mr. Kendrick's motion seeks to recuse Judge Glanville for his involvement in the allegedly improper and coercive ex parte meeting with the state. On June 14, 2024, Judge Glanville denied the motion. Judge Glanville determined the recusal motion was timely, supported by an affidavit, and on a cursory review, contains assertions of fact to support the allegations of bias and partiality. And then she said, look at Adams DKT 247. However, Judge Glanville ultimately determined that because there was no way to verify the veracity of the information contained in the affidavit, and there was no actual evidence of the extent of the discussion during the in-chambers meeting, the affidavit was legally insufficient, and the motion to recuse did not require referral to another judge for consideration, ID. On June 14th, 2024, Caleb Bumpus then filed a motion to quash the show cause order and or to recuse Judge Glanville from presiding over any contempt action against Ms. Bumpus resulting from alleged disclosure of the ex parte meeting. On June 17, 2024, Jeffrey Williams filed his motion to recuse Judge Glanville. Williams, DKT, and that's docket number 587. Divorced from his hyperbole, and so she called his wordplay hyperbole because he said a lot of things about what they've done and the way they've done it, and them becoming cohorts and team members. He was correct in that. The judge becoming a part of the prosecution, and so she didn't like all of that. So she said, apart from that, Mr. Williams' motion and supplement also seeks to recuse Judge Glanville because of his involvement in the ex parte meeting, which Mr. Williams also alleges was improper and coercive. Mr. Williams' motion alleges both actual biases and appearance of bias because Judge Glanville allegedly participated in the accusatory process when he met with Mr. Copeland, and Judge Glanville became embroiled in a controversy when he held Mr. Williams' lawyer, Mr. Brian Steele, in contempt. On July 1st, 2024, the day appointed for the parties to review the redacted transcript of the ex parte meeting, Judge Glanville announced that he was releasing the entirety of the transcript of the ex parte meeting and was taking judicial notice of and making a record regarding certain matters associated with the ex parte meeting. Most of what Judge Glanville relied on was a collation of record evidence about the recent circumstances in the case. Judge Glanville also explained how he became aware of the state's request for an ex parte meeting. In addressing the circumstances of the contempt against Mr. Steele, Judge Glanville explained that the court's purpose and concern in pursuing information about the security and confidentiality of his chambers. So now she's making it like he did about his chambers, not about what happened, and she didn't tell how he said he became aware of that meeting. Judge Glanville advised that he had not instigated an investigation into surveillance footage, but had reviewed such footage for timeline and security. Actually, he claimed someone brought him the footage where Kayla was talking to the other attorneys out in the hallway, and that was wrong. Judge Glanville then explained his view that the ex parte meeting was proper under Georgia law and outlined relevant law that supported his inherent authority to hold such a meeting. Judge Glanville maintained that no one gained a tactical advantage as a result of the ex parte nature of the meeting. Well, that can't be true because they needed Mr. Copeland to testify in order for them to get all of these videos in. So there's no way that that judge can say that and mean it. So she's just saying anything and mean none of it. Judge Glanville also questioned defendants' right to be present at the ex parte meeting because the issue under discussion was between the state and a witness who was represented by counsel. Now he's represented by counsel. After making this record, Judge Glanville announced that the show cause hearing was canceled and that the recusal motion filed by Mr. Kendrick, Mr. Williams, and Ms. Bumpers were being referred for consideration by another judge in accordance with the Uniform Superior Court Rule 2.1 through 2.7. The motions to recuse were then assigned to the court for consideration. She didn't tell that they had filed a motion of mandamus, and because they didn't file with the Superior Court first, that they referred it back to them and told them that he had to do it that way. She didn't mention that. So she's making everything seem like it was done above board and correct when none of that is true. Motions to recuse, we don't want to read that because we know what they are. I just read what they were. So we want to go down here to her analysis and discussion. Here, Judge Glanville had previously announced on the record that the motions were timely and supported by an affidavit. In transferring the cases to another judge for consideration, Judge Glanville necessarily determined that the third criteria was satisfied, that recusal might be authorized if the facts alleged in the motion were assumed true. Therefore, Judge Glanville was required to refer the motion for reassignment and was prohibited from opposing the motion. And so she's saying that's the only thing he did wrong, was he opposed the motion and made his own decision. It is worth noting that the court agrees generally with Judge Glanville's assessment of the propriety of the ex parte meeting. How can she do that? We'll never know, but she does. While the meeting could have and perhaps should have taken place in open court, nothing about the fact of the meeting or the substance discussed was inherently improper. She's lying because the judge knew things that they didn't even discuss in the meeting. And that's what was amazing, because the judge asked them, don't you have some questions for him? Why would she be asking that question? Don't you have some questions for him if, in fact, he didn't already knew that they had questions? Where would he get that idea from? And it looked like I'm looking at this, and it looked like y'all not seeing none of this that I'm reading. I'm just reading my little butt off, but y'all not seeing it. And I'm sorry about that. So, she's just going along with the get along, and all she's doing is making it so that they could not ask for dismissal and get it. Now, they still may get it because everything that happened really did happen, even though she didn't acknowledge it in her order. And, you know, that's what they do, because normally when you go to appeals, they go with the last court that make a decision on your case. But they have gone really far beyond the pale, so I don't think that it's just going to end like this. She said, however, in his order denying defendant Kendrick's motion, and in the process of making his record on July 1st, 2024, Judge Glanville added facts, provided context, questioned the veracity of the allegations, and otherwise explained his decisions and actions, and argued why those actions were proper. That's where she said he only messed up there. While it may be appropriate for the judge to disclose information relevant to his potential recusal, such a disclosure must be made in a way that is objective, dispassionate, and non-argumentative as possible, so that the judge is not reasonably perceived as a hostile witness or advocate. In presenting his record as to the recusal and issues and the ruling in Kendrick's motion, Judge Glanville evaluated and accepted the truth of his own factual allegations mandating his recusal. She gave case law. This court has no doubt that Judge Glanville can and would continue presiding fairly over this matter if the recusal motions were denied, but the necessity of preserving the public's confidence in the judicial system weighs in favor of excusing Judge Glanville from further handling this case. So she's going to excuse him. Based on the foregoing, this court hereby orders as follows. Defendant DeMonte Kendrick motion to recuse Chief Judge Earl Granville is granted. Kayla Bumpus is moot because she's granted their recusal, so he doesn't have to listen to anything about showing cause. And Mr. Williams is granted. And then the clerk should reassign. So the clerk did do the reassigning. And in the reassigning that the clerk did, it just so happened that the first lady recused herself from the case because she was involved in another one of the defendants' case where one of her bailiffs in her courtroom actually was believed to be dating that young man, and they had some behavior that got the young lady arrested. So she walked away. And then we have a new judge, another one that was assigned today, and it turned out 2 years ago, Brian Steele, Mr. Botts, and Mr. Harvey, I think, they are a group of attorneys that gave a luncheon fundraiser for her. And so I don't know if they're going to excuse her or she's going to recuse, because that judge was given $2,000 and she didn't recuse herself. So I don't know. Regina said Fulton County Judge Shakura Ingram was set to replace Glanville but disqualified. Yeah, that's the one I was talking about Wednesday, shortly after she was assigned to it because of an appearance of impropriety. So at least she did the right thing. Yeah, Paige Whitaker. Now that's the one that you heard Mr. Melnick mention, that Judge Whitaker was in on one of Kenneth Copeland charges back when they very first started talking about this case in 2021. So if they haven't had something to do with the judge or the lawyers that done had something to do with the defendants. So everybody done had something to do with everybody, it appears. Judge Whitaker and Judge Krause. So it's really strange. But both of those judges have been judges over Kenneth Copeland's cases in the past. So it's these kind of things, though, that's so very unfair to us as a people. And everybody's excited that he got moved. But look at how she removed him. She removed them blemish free. Spot clear. It's not like Miss Love did all the stupid stuff that she did and accused Mr. Thiel of lying in the courtroom in front of the jury and stuff. And the way she did it, and most of the time she did it, they were not in front of the jury. They had stopped it and started, doing it once he excused the jury, but it started in front of the jury. They ran out of judges, then they asked them to actually recuse the whole Superior Court and just bring somebody from somewhere else. But when you look at that Orca money and the incentive that these people have, are you really getting somebody that's going to be non-biased, that's going to be fair? Because to me, they're all driven by the money. Now, I could be wrong, but that's all I can see out of this whole situation. It's not about whether these guys are guilty or innocent, because Young Thug has no record. And I think he may have had a juvenile record, but it didn't carry to his adulthood. He's not a convicted felon. A lot of those guys have already served their time, but they're saying because when they did it back 11 to 10 years ago, 12 even for some, that it was indicative of RICO because they were doing it in furtherance of the gang, which is no gang. And if anybody are gang members, then you could consider them gang members as the Divine Nine, because quite a few of them belong to those beautiful organizations that they love to, parade around at conventions. I don't know anybody that they help. I'm sure they help somebody. But what's so sad about it all, even those organizations and the ones that are real gangs like in California, in Illinois, in the states, Florida, in Louisiana, even in Texas, where some of these gangs are known, they all started as protection of their community against a force that was supposed to protect them, but was actually taking them out. So it's really sad how these organizations started supposedly to help each other gain employment and to get educated in dignity and respect. But it all turned out to be about conferences and how many dues you pay so that you can stay active. But you know of nobody, and I'm sure it's somebody getting help. So when I say nobody, I'm not talking about all, I'm just talking about, the majority of everything, not the all of nothing. But it's just really sad how we have to put up with so much and we can't have the real conversation. Like I found some information, I did a short on some of the history that our county clerk found back in the day, the people that were bought and sold here in Dallas County, and they restricted advertisement on it. And I just can't see a company that won't advertise on that video, but they advertise on what they want. But the amazing thing to me is everybody can discuss what happened to us, our history, but us. We can never have the real conversation, and we don't have the platforms or the network so that we can be able to do that. And certainly don't have the people that's interested in the conversation. But we're all affected by the decisions that's being made, and we're not participating. And I know that there are worker bees and everything, so everybody is not going to participate in the work. But it would be good if we could just have the conversation and, an honest conversation. But that's very hard to do when you don't own anything and you're depending on somebody else to give you the avenue or the tools to do it. It's very, very hard to do. So I understand that. But these judges are recusing themselves left and right. And these guys still are held without bond. And if you don't have a judge on the case, you certainly can't go before the judge to ask for a bond. And I heard a lady, she was making a lot of sense the other night on another guy's show. But then she started talking real crazy, in my opinion. I'm like, my God, how you go from that to that? Regina said, if anything, Fulton County judiciary system gives the appearance of game. Yes, they do. Than who they are trying to pin a gang title on under RICO. Yeah, I could see them very much going under RICO, federal RICO. Because, my true belief is, they're operating in a system that's been in place ever since we've known of a system. And so it didn't just get like this, and it didn't just get ran like this. It's just there used to be different people that did it. But what gets me is that we as a people pretend if we get an opportunity to do something different, we would be different and we would do different. And we find that human nature shows you different. We get in there and we do the same thing. Matter of fact, we do worse because we got to prove something to somebody that we can be worse than you were. And we mistreat people even worse. All of the money that they're taking in and, the homeless that they have. And again, they want that cop city so bad. And everybody's against that cop city. It's like militarized policing. And that's what they want. And then a lot of people get angry because you can see things. And then they say, well, whose side are you on? Mine. I'm on my side. Why don't you understand that? The Republicans, the Democrats, those are the left and the right wing of one bird. The mind, the head leads. And they're going to follow. They give us these games to play with our emotions and to control us in the way we think and feel. They don't teach us knowledge. We have to seek it. And we refuse to seek it. So I don't know anything else to tell us but what I get out here and try to tell us every opportunity that I get. Everybody can cover this case with all sensationalism. And it can be sensational. But it's people hurting. Families are affected. And that's from the crimes that these young men committed, for the crimes that they're accused of committing that they didn't do. Because all of us are supposed to be under the presumption of innocence. But of course, we know that it doesn't work like that in the real world. And it shows every day. But the way that lady wrote that paper up, there's no way nobody would look at that and would give a mistrial, because you can't see anything that was done wrong. And the only thing that she's equating to wrong is she did recuse him. So the work has been done. And she recused him from the entire case. But no, it's only just begun. And Bonnie Willis can pretend she's going to bring these cases back. But now they're going to have to do something to try to stretch to get the rest of this money that they haven't spent for this year. The Orca money. That's basically what it's all about. And that's my opinion. And they can show me different, but you would definitely have to show me, because I can't buy it any other way. That's all I see is the Orca money. And as we know, our rights are steadily being diminished every day, every chance that they get. Our rights are being, just totally wiped out. And we as individuals are going to have to, step up and learn our rights and then start enforcing those rights, holding them to the Constitution. We've got to hold them to it. Because if we don't, then we're no better than them. If you have a right and you fail to claim a right, then you really don't have that right. And certainly not the right to complain. And of course, we love to complain, but we don't want to take responsibility and make things work for our good. Because they can work. We just got to put in the work. And that's kind of hard. It's kind of like the blind leading the blind. But if we both fall in the ditch, at least we'll be together. And we would have tried. That's the way I see it. Is that we would have tried. We would have given it our all. And that's all that's required of anybody if you're going to do something. Is put forth your best effort. That's all you can do. I was trying to go back to that original document because he had a lot of the instances, and we saw some of them. The things that she actually just blatantly did. Regina said, Fonnie Willis is done come November. Let's see if her corrupted black blasphemous clergy continue to stand behind her. They're all driven by money. Yeah, no, they gone. You already know. They already gone. She can consider herself out of there, even though she just got voted in office. But the table is going to turn. And we all know that it's going to turn. It's really sad that it's like that. But it's not, fear is what they use to keep us quiet, to keep us so-called in our place. But our place is to be who we are and be authentically who we are. And, it's not easy. It's hard. But it has to be done. I was trying to see if I could find that motion that I had up, but I'm always knocking stuff down, so I don't know where it is on this paper. But then we have the young man that tried to take out Donald Trump, and that's just the strangest thing in America to me. For a 20-year-old who was about, 14 or 16 when Trump was president. It makes no sense to me. I'm sure it makes sense to somebody, but I don't get that. Doesn't make sense to me. But yet again, I'm glad that he is safe. I hate that the people that were injured and lost their lives had to, do that. But we got a whole lot to think about and a whole lot to prepare for, which is the future. I had came up with some ways that Abraham Lincoln and Donald Trump are considered a lot alike. And I found an article And I don't like the way it look on here. And let me try to find it and put it on a Word document. I read better that way. I can barely see. I can see with these reading glasses. I broke my good ones that I like and haven't found any more good ones. And every now and then they be doing weird stuff. Okay, let me put this on here so I can share this, you know, the comparison that has been made. I know I just copied that. Okay, let me try to copy it again, because it didn't come out on the document. Man, I didn't know that was there. Give me a second, y'all. I'm trying to copy this page. Okay, let's see. Let's do copy. And let's do this. I guess it's just taking a minute or two for it to... It's like it's 20 pages. It ain't nothing but a couple of paragraphs. But it's just taking so long to come down. Yeah, I just saw something, but now I don't see nothing. I don't understand that. I may have to go ahead and read it the way it is because it's not acting right. Let me just go ahead and read it the way it is, y'all. I don't like the way it looks, but that's what it is, so I'm gonna have to go with it. It says, how are Donald Trump and Abraham Lincoln similar? Let us count the ways. Perspective by Gene Weingarten. Columnist, October 11, 2018 at 9 a.m. And this is the Washington Post. There is a meme spreading earnestly across the right aisles of the internet contending that Donald Trump is such a great president that the only predecessor he can be fairly compared to is Abraham Lincoln. This thesis was cemented into public consciousness by the latest film from the noted far-right history warping conservative commentator Dinesh D. Feckable D. Sousa, which explicitly makes the comparison. Okay. The poster for the film has Lincoln's face morphing into Trump's. Rather than make fun of this contention, as a representative of the beleaguered mainstream media falsely accused of bias, I decided to do my best to dispassionately examine and evaluate it. To assure accuracy and even-handedness, I consulted my good friend and colleague David Von Drill, who is an actual Lincoln scholar. Surprisingly, perhaps, we found the Trump-Lincoln comparison to be defensible. Here are the highlights of our investigation. There are two in which our sourcing is a little thin. See if you can guess which. 1. Lincoln and Trump are the only two presidents to have declared war on half the country. 2. Both men won in elections where the black vote was suppressed. 3. Both men were Republicans who defeated Democrats in 1860. The Republican Party favored social progressivism and bigger government, and Democrats opposed these things, but still, undeniably, both men were Republicans who defeated Democrats. Lincoln suffered from depression. Trump finds many things sad. In his youth, Lincoln was a highly respected wrestler, voted into the National Wrestling Hall of Fame for his reputed 300-1 record in neighborhood bouts. Donald Trump was voted into the World Wrestling Entertainment, Inc. Hall of Fame for sucker punching Vince McMahon at ringside and then putting shaving cream on his head and shaving him bald. Lincoln was once closely associated with wigs. Trump, well, you know. Speaking of which, Trump and Lincoln each had notoriously unruly hair. In a stiff wind, Trump's curly-Q comb over has been known to lift up and off like a 747, leaving a tarmac of flesh. While visiting troops at Fort Monroe, Lincoln was once offered an elegant hairbrush by a wealthy officer. "I can't do anything with such a thing as that," Lincoln replied. "It wouldn't go through my hair. Now, if you have anything you comb your horse's mane with, that might do." Both men were fat. It's just that the verticality of Lincoln's stovepipe hat was extremely slimming. Lincoln probably wished he never heard the name Ford. So does Trump. It is not widely known, but in the latter years, Lincoln left Mary for a Slovenian supermodel. Both Trump and Lincoln were famous for introspective quotes. Lincoln: "I pass my life in preventing the storm from blowing down the tent, and I drive in the pegs as fast as they are pulled up." Trump: "Nobody's ever done a better job than I'm doing as president, that I can tell you." I think we'll leave it there. And that was from Gene Weingarten. What do y'all think? Gene is a writer and an editor for the Post from 1990 to 2021. Has won 2 Pulitzer Prizes. They were not for putting poop jokes in the style invitational. I could barely see that. That was awfully small. So what do y'all think about that? Anything that y'all think is actually true? They could be alike? Let me see what Regina said. Regina said, in my opinion, Fannie Willis is done come November. Okay, I read that, I think. Yes. Let's see if her corrupted black... Yep, I read that. Yeah, so on that note, I think that we're going to get ready to close it out because I've covered what I want to cover, and that is that we don't know what's going to happen. There's a lot of speculation, and we'll just see, but I would like to see them deal with this lady and what she came up with and go ahead and ask for dismissal or mistrial with prejudice, but they're going to have to show the prosecutorial misconduct and the judicial misconduct because she strictly wrote that all out of the record as if it does not exist. Oh, that's okay, Regina. Yeah, but, you know, she just wrote that stuff straight out. I just don't know how she wrote that out of the thing, but she wrote it straight out as if it didn't exist. And that's unbelievable what she has done. And, you know, everybody, they talk about it, but it's almost like it's a joke. And, you know, none of this stuff is a joke because that's these guys' life. And the conditions in which they have Jeffrey Williams locked up, like Mrs. Steele said, they keep the lights on him. His kidneys at one time was failing him, and he had to go to the hospital. So this could be really some life or death situations because they've even had those type of situations. You know, they're in the jail where some people went in there for misdemeanor offenses, and unfortunately they haven't, and they're not going to be able to come home. So it's really something to think about, and it's good, you know, to find some humor, but this stuff is really serious, and what's going on in our communities is very serious. The gentrification, the gerrymandering, you know, it's the people that are getting ready to leave office soon. There's no one that's being prepared to take their place. So we have people here in Dallas that fought for 14-1, and the 14-1 is for seats on our city council to be more reflective of the population in the city. But a lot of people that are going to be leaving office, they can't run again because they've served their 2 terms. And I don't know anybody that's really being groomed, as they call it, and prepared to run and step in those seats. So it could very well go back to what all these people fought for. It could very well go back to just everybody looking one way and none of them reflecting us and our portion of the city, where they're trying to rezone everything because a lot of people are moving here and they're building a lot of new homes, and they're building the new homes, not building the homes so that people can live in the homes. They're building the homes for Airbnbs. That's what they're doing. They're building Airbnbs for people to be able to rent the homes and companies to rent the homes out. And they're in our neighborhoods where we grew up because we're real close to downtown Dallas. So a lot of people are not paying attention to what's really going on, and it's unfortunate because for us, everything seems to be a joke. Nothing is never really serious. But there's going to come a time when we're going to wish that we didn't laugh so much, and that we had, you know, taken the time to learn some things. And you don't have to take a lot of time out of your day. You could just take some time out of your day. And, do your best to educate yourself and educate your babies on the things they should know and the way that they should go. Because it's really, really hard out here. The economy is bad and food prices are going up. No salaries are going up. More and more people are getting sick and are on medications. And a lot of your money is going to medical and medications. And that's unfortunate. But that's the way it's turning out. So, it's going to be interesting to see how all of this stuff play out. Yeah, if we're going to get a new judge, if this judge is going to stay, the one that was given the dinner. I don't know if she's going to stay or if she's going to decide that, well, she want to recuse herself. But if the other lady didn't recuse herself, I don't see it happening. So, I don't know. We'll just have to wait and see. I was trying to see if I could pull this up before I left here. Because I'll be leaving in just a few. Yeah, it's going to be very interesting how this stuff is going to play out, though. It's already just devastating. I don't know what the parents could be going through and the siblings when it ain't nothing you can do about what's happening, to your loved one. That's what's sad. You just have to watch this happen. Okay, let me see. I think this might be it. I was trying to see if we can find some more of those, some of those YouTube videos that he had to show the court just how bad, things were. But I have to see what's the time stamp. Okay, this is okay. Oh, this is one I think I've been looking for. Okay, this is yes, yet the court's bias is so deep that the court refused to instruct the jury that the court's declaration was completely wrong on both occasions, and undersigned counsel was neither unprofessional or unprepared. And this looked like the video dated January 22nd. Okay, that must be the one above. Let me see. Let's see. YouTube. 428. The court remained silent while lawyer Love hurled more false accusations. In the jury's presence on separate occasions, the court wrongly accused undersigned counsel of being unprofessional and unprepared. Okay. Let's see if this is it. March 20th, 2:36. Let's see if I can see if this is it. March 20th. We look for the date. This is January 22nd. What did he say happened on January 22nd? Professional. Dated January 22nd. 45 to 47. Okay, let me see. The way they have these written, it's kind of hard to tell what he's talking about. That's June 7th, 428 to 453. Okay, let's try this. See YouTube dated January 22nd, 2024. 45 to 47. Okay, let's see this one, y'all. This is January 22nd. Forty-five to 47:30. Okay, I'm gonna start it there.
Thank you. Mr. Stevens, were you able to view what Mr. Kokomo showed you as Mr. Williams number 37?
Yes.
And is that an accurate depiction of what you described earlier of seeing the Super Bowl with a performer named Snoop Dogg?
Yes.
And was he making the references for the observations that you described to the jurors about the walk and the using the hand?
Yes.
And are there any, to your knowledge, deletions or additions or modifications? Meaning, were there any changes made to that, or is that how you remember it?
Yes, I remember.
Okay, Your Honor, I move for the admission of Mr. Williams, number 37.
Any objection to Defendant Williams 37, madam?
No objection as to the video being played without sound and at the timestamps that Mr. Kokomo said that they would be played for Mr. Steele.
I'd like to play the sound and the entirety.
Have you seen the entirety of it? Would you? All right. Why don't you just? How long is it? Just come on up here and let's play it. I mean, and screen it. This would have been nice for you to do before we got in here this morning, Mr. Steele. So please, in the future, don't do this to all of us, okay? Okay, sir, I'm talking to you.
Yes, sir.
Okay. This is not professional. Ladies and gentlemen, would you like to take a 5-minute recess?
Yes.
Okay, all right, why don't we do that?
Yeah.
Yeah.
You just said sound though. He said you all work with him. What's that?
We're going to play some music.
Now, if you don't think that judge had some problems, that man never should have been in a courtroom. I know he wanted the money, but really, he just shouldn't have done it. That was ridiculous. Okay, let's look at the next one. Let's look at the next one, y'all. Okay, let's see where we are. On this one, we're going to be this should be dated March 20th, 2/36/51. $236.51. Okay, let's see what this one is talking about. These are things that he was showing this judge, that the improprieties, but she left all of this out. $236.51. So we have to start at 236.28.
Yes, sir. Probably do not. There is an objection, but the prosecutor trying to figure out which jail call I did more. On 30 day addition 3, tell us which ones they are.
I did identify 2 of the 3 that are the newer calls that have not been admitted. I identified one, and I'll call it, for the purposes of this, the chicken call, because it stands out because she's talking about cooking fried chicken. The second call after that is a call where she's at the baseball game, and that's very identifiable. It is the third call that I advised that I will ask the court if we can take a brief break so I can just identify which call that is so that they can know. But I've identified that 2 of the 3 calls.
Do you have any objections to the baseball or chicken call? I know it's just wrong. Do you have your video yet? Yeah. Who else? Why do I need more time? Because you said to let you know if the issue comes up. Okay, but do you have any specific objections to those two calls? Not the third one that we're going to need to take a break on. As I told you, I may have, I may not. But you were going to, you told me to let you know. So I told you. Following your direction. Mr. Steele, please don't try and engage in conversation. You're not prepared. Because if you prepared, you'd have told me. You invited this conversation. I did. I asked you if you were ready. If you were ready, you say, yes, Judge, I'm ready. After you do those two calls. Now, if you're not ready, then go ahead and just tell me you're not ready, and we'll go ahead. I'll go ahead and we'll figure out something else to do. But if you have any other basis, then tell me. You instructed me and raised this already. You know exactly what I'm talking about. No, I said no. Then we need to ask the jurors, like you need to cite the question. How long is this third one? They're all 15, 20 minutes.
Right, and I will say for the third call, Your Honor, really as it relates to this particular incident, there's only two relevant areas from 00 to 1 minute, and then 3 minutes and 50 seconds to 6:40 are the only relevant parts, I believe, for this particular matter.
Are you going to want all of the third call to be played? Maybe. I tell you what. How long was the third call?
So all the calls, Mr. Steele is correct. All the calls are approximately 15 minutes, and the state does intend to play all 5 calls.
Your time, as much time as you want. I'm sure to refresh your memory. No, I'm talking about the third. I'm talking about the third call. But I need the court instructed me. I don't know why we're doing this. The court instructed me to help the court. That's what I'm doing. When it comes up, that's what you instruct me. So I'm following what you asked me to do. Now you're acting like I'm not prepared. I'm very. All right, I tell you what, will 20 minutes be sufficient for you to review short? All right, ladies and gentlemen, we're going to take 20 minutes, and after that, we'll come back and continue with the second
All right.
All right, ladies and gentlemen, please be seated. Your technical seat 20 minutes, okay?
Yes, sir.
Do I need to listen to the call?
You don't. Adjourn this break. When we come back, we'll just want to know a decision about the transcript, because we do have a transcript for the first call, and that was the one we gave to them yesterday. So just a decision about.
Well, I thought you were going to take more time for that because.
They have not looked at it. Okay, never mind. Thank you, Your Honor.
All right, okay. We're in recess about 20 minutes.
I have a motion.
In regards to what, sir?
Your comments. I have a motion.
Okay, what's your motion?
Right.
This is the second time that this honorable court in front of the jury has addressed me inappropriately and wrongly. Second time. The first time I gave the state discovery of a song from a Super Bowl. Weeks before, there was an objection. You assumed that I didn't give it to the state. I didn't want to embarrass the court. So you were yelling at me and saying, do you understand me? Do you understand me? And instead of saying, do you understand that you're wrong? I sat here and I said, yes, Your Honor. That was to protect the integrity of this courtroom and the court. Now you say in front of the jury how unprepared I am. I am not unprepared for anything.
Okay,
I have no.
Steele,
I need to make
Mr.
a
Steele,
record. Your Honor,
Mr. Steele, wait a second.
Record.
When you keep delaying, okay, and that's what's happening to the court. You keep delaying and elongating and pushing out these particular our ability to present a seamless case in front of the jury. That's my purview as a judge. And I've asked you a number of times, you and your colleagues on both sides, to go ahead and listen to whatever it is you need to do, prepare me as needed. Now, I asked you those two particular questions because if they turned over the audio to you in discovery and you've listened to them already, then you either have an objection or you don't have an objection. And I was trying to solicit from you whether or not we could just go ahead and just hear it. So you can imagine my frustration because all these little delays just elongate out our presentation in front of the jury. That's for your benefit, not for mine, Your Honor. So that's why I've told you all at various times during this particular case. It's not because I want to embarrass you, Mr. Steele. It's just that I'm trying to kind of keep this thing presented in a way that the jury can listen to it.
And the court is wrong. What happened was, let me finish, and I'm making this for the record. What happened is, and I don't get embarrassed by you, but I don't want to embarrass you. I made an objection that some of these jail calls have a third party who will not testify. I objected to hearsay. The state said it explains the effect.
Okay, which call?
These calls, as you.
Okay, well then why aren't we taking them up beforehand?
The state just said, just now, these are the 3 additional calls that they want to introduce.
All right. Well, then here's your response. I'm going to give you an acceptable response.
Well, I'm going to make my motion.
Huh?
I need to make my motion.
Judge, there's more to this than we need to listen to these calls.
Right.
Then I would have no, you didn't say that though. So I wouldn't have had that opportunity. But that's why I keep telling you this, okay? I mean, like I told you, forewarned judge, a happy judge. All right, so had you just told me up front, Judge, we have not had the opportunity to listen to all of those calls. We've only been able to listen to 2. I want to listen to the other ones. And
I've listened to the calls. I know. I don't know what the third one they're trying to do.
Okay, well,
listen, let me just finish. So you presuppose I don't know what the calls are. Well, I don't know what the third call is because Ms. Hilton, who's professional, said, I'll take a break and I'll let you know what it is. But the other 2 calls are the baseball game and at the they're discussing chicken wings. Or chicken. I understand those calls. There's issues in those calls that you need to address. But I politely make an objection and say, Your Honor, based upon what you told me, which is what you told me, we'll take it up later. I wanted to raise it. You tell in front of the jury how unprepared I am. And let me tell you something. I am not unprepared. I don't appreciate the court telling me that. And you don't, and I asked you, tell the jurors that you were wrong when you admonished me last time. You said you wouldn't do that. This is the second time. And you know what it does to me? I don't care. I'm hurt because you're a court, but I really don't care. But what does it do to Mr. Williams?
Mr. Steele, I'm not trying to personally insult you or hurt your feelings, okay? You are a grown professional advocate. I'm a grown professional jurist. And people say things to me that border on the lines of I could take action or not. You have certainly said some of those things to me during the trial of this case. I have let them go. So, sir, that's just the trial. That's just the trial of the case, okay?
No, but that man's life is here.
And you know you're doing a fine job in representing him. Well, but you know what? That's just the way we are right now. But the crux of the issue is, Mr. Steele, and the representatives from the state and everybody else. What happens right now is I have to take a break in order to vet all of these issues, which I'm required to do, Mr. Steele. And that's what is kind of disappointing to me because I have given you all this administrative time, all these breaks to go ahead and do this. And this is what delays the presentation of this case in front of the jury.
You know, if I would have done what the state did and I'm not poking anything at Ms. Hilton, you would have said to me, Why didn't you share those calls with him before? What, you were out all day today. We didn't start court till 1 o'clock. I would have shared them.
I know you would have.
But the state didn't. I'm not poking fun because I can deal with it. But when the
you know
court
what?
then steps
But
in,
here's the problem. I have a problem with it because here's, at the end of the day, I got to listen to a 15-minute call.
you don't have to listen to anything.
But
You have to make a ruling
yes,
on it.
but I have to listen to it in order to make the ruling on those. And even if you said you've listened to the chicken call and the baseball call, and if you say there's other issues that come into play, it's better for us to take those things up before I ask for that jury. And I could have done that this morning. I could have done that at another point in time. So, I mean,
Well, I raised this issue to you, and I don't remember the date, but it was days ago. I raised it, and the court said, all right, understood, and we'll take that issue up when it comes. Now, what am I supposed to do?
Okay.
Sit there and say no objection?
no,
Exactly right.
not at all.
I said, Judge, it's an issue
Not
we
at
need
all.
to take up.
Not at all.
And in addition to that, today alone, and this happens, today alone, the state introduced 2 exhibits. I've never been given them before, ever. You know what I did? No problem. No problem. Because I think that's professional. One was a Google map. It needs to be clarified for the record that it was not done on September 11, 2013. And then a map with little dots with 0.4 miles. I've never seen before. But I didn't do anything, Your Honor. I want to move the case. But when the court, it gives me no pleasure in saying this. I believe that this honorable court is biased against Mr. Williams and or his counsel. And I ask you to consider recusing yourself or don't do this again to me. This is inappropriate to me. I respect you, but what am I supposed to do? Sit there while you do this? I didn't do anything wrong. I did exactly what you teach me to do and the courts teach me to do.
All right.
But instead, no, I got to finish this. Then I get told to this court says by Prosecutor Love that I'm not being candid with the court and I'm misrepresenting because Mr. Bean never went to the hospital at Grady on September 11, 2013, and Miss Love has a document on the desk to prove it. I sat right in front of Your Honor at the table, at the bench, and I said, I'd be careful what you say. It's not accurate. Mr. Love looked down on me and she said, it is accurate. You said, we'll take a break, figure it out. After the break, you didn't even bat an eye. Ms. Love said, yeah, I was totally wrong. Mr. Steele's right. He was taken to Grady. If I would have done that and called another member of the bar disingenuous, not truthful, no candor, and misrepresenting, you would have had me yelling in front of a jury. You did nothing. You didn't even ask Ms. Love to apologize. I don't want her apology. I don't care about Ms. Love. But I care about the court. And now if you can walk in someone else's shoes just for a minute and see what you're doing to Mr. Williams, because it's hurtful. I'm not the one wasting time. I'm here every day ready to go. I am not wasting the time. I make a motion to ask you to please recuse yourself. I know it has to be in writing within 5 days. If you want me to do that, I'll do it. And it has to go to another judge. But this is what's going on, Your Honor, whether you see it or not. You're yelling at me in front of a jury for nothing. And then you won't apologize. And I did nothing wrong ever on these occasions or others.
I'm going to go ahead and address your motion at this point in time. I'm going to deny your motion at this point in time. And also just direct you that I had the responsibility to control the proceedings in this particular circumstance. Sometimes things get kind of heated, and that's that's the crucible and trial of any particular case. I am not in any way intimating or insinuating that you are not professional, you are not prepared, but the things that I am bringing up to both of you, and I have fussed at both sides for this particular issue of not being prepared in the sense of, and the only reason it affects the trial of the case is it makes the proceedings a lot longer than they should be, because all these things could be taken up. And sometimes if we've got to parse out all these things, as you can see right now, it takes time, and that's what I'm kind of concerned about, having been a jurist for a long time. So, I understand that you're a zealous advocate. You in no way offend me by by raising any type of motion. I think you're doing I think that you and the others here are representing your clients well, but sir, I have to be able to control these proceedings. And you at times in these proceedings have not listened to what the court's told you, and I certainly could have explored other options. I didn't. So I'll tell you that much for what it's worth.
You allowed a member of the bar yesterday ask a witness who constantly is committing respectfully, potentially perjury. Did Mr. Steele shut off and turn on the recording? I never did that. I wouldn't do that, and I didn't do that.
Okay, and but sir,
I would have said that question about another member of the bar, prosecution. You would have come over the bench and said, "How dare you?" I sat there and I said, "Outrageous." You denied the motion. I think 3 other people made motions to strike or to object. You denied it. Judge, I'm just telling you, the appearance, if not the reality, is not good here. I'm being...
What, to who?
To Mr. Williams.
Okay, but...
Maybe to the others. Maybe
you're his advocate, okay? And that separate issue of whether or not you did what you did, the state accused you of that. They have the right to at least inquire about whether or not that happened. And whether or not it happened or not, I'm not making any comment on it, but it goes to bias, it goes to motives to misrepresent.
That never happened. No good faith.
But I'm not commenting on that. That's for the jury. That's for the jury to decide.
I asked a question about a missing recording that wasn't given of a statement made by Mr. Bean. And you know what you told me?
And I keep telling you.
Know what you told me? You said, does the state have it? They said no. You said, nothing I can do. I tried to cross on it. You sustained an objection.
Because it doesn't exist at this point in time. Now, if it exists at some point, I told you I'd say it. 1, I tell you, I apologize to you. And then 2, I'll take corrective action against the party or the entity that failed to give you that particular statement.
But the point is, everyone knows he spoke to the detective beforehand.
No, we don't. That's the whole thing. You believe it. You honestly believe it, and that's true.
On September 17th, 2013, on recording, Mr. Bean tells that to Detective Quinn. How is that far-fetched? Why would he ever say that? I lied to the other detective. Why would he ever say that? I mean, logic has to come into this courtroom at times. But you stop me from doing it, but you allow another lawyer make up that I'm stopping and starting a recording. And he says, well, I don't recall. I don't remember anything.
Here's the thing. That's why probably Miss Love asked me to put it under seal for the time being. But I mean, I'm not saying anything, but if true, that's a pretty serious accusation.
If true, I'll die right now. How about that, Judge Glanville?
Your Honor, I object to this.
I don't care about her objection. I'm speaking with the court.
Your Honor, I object.
I'm speaking with the court.
Okay.
I'm speaking with the court.
Let him finish, and then you can state your...
My point is, if you don't see what's going on, it's because you're not viewing it out of the lens of a juror.
Mr. Steele, I can't do that. I have to be the referee. So the jury decides those particular issues of believability and credibility. Now, I'm not getting into the throes of war between you and the state. That's your business, and that is certainly
nothing to do with a throw of war.
No, but I mean, it's your ability as an advocate. I told you before. That's your ability as an advocate. All right.
What I'm saying is, you said in front of this jury, I was unprofessional. I am not unprofessional. You were wrong.
I think at that particular point in time, given the totality of what happened, that's what the court's assessment was. Sir, I am...
But it was wrong.
It's a snippet in time. Mr. Steele, you're a very good attorney, but I'm a professional jurist, and you may not like some of the rulings that I make, and you may not like the way that the trial is going at a particular point in time. That's for all advocates. Ms. Love and her colleagues, I've told them the same thing. But I think that my job as the referee is to give you a fair trial. And that's what I'm going to do.
Well, I hope that's true. But you just told the jury I'm unprepared. And I am prepared. I don't understand why you would say that.
Both of you, and I'll level this against the state. Both of you, that's being unprepared, because that I have to then listen to this to rule on it.
I understand, but I'm the only one that the jurors here, the court, take ire with. Ever. Without an apology, without...
Oh, I think I've taken Miss Love and Miss Hilton and her colleagues to task many times.
No, I've heard you yell.
I've taken them to task as well.
I've heard you say to her, "Stop interrupting me. Answer my
that's
question."
that's taking them to task.
The jurors never heard that. Ever. So I asked for a continuing recusal motion. And I know it's not in writing, but I assume that you're ruling on it right now. That's what you're saying.
Well, one, you got to put it in writing, but I mean, I'll rule on it at this point in time. I'm going to deny the motion, but you need to put it in writing if that's what you wish to do, and I'll appropriately.
I'm also asking for a mistrial based upon your statements. I think I made that clear, but I'm asking for a mistrial.
Okay, now,
I don't think it's a fair forum for Mr. Williams.
Okay.
And I don't want to ask for a mistrial, but I have no choice when the court is saying what it said, and I'm not going to repeat it in front of a jury. That's hurtful. And I'm not saying me. I mean, regardless of what I think of it, it's hurtful to Mr. Williams getting a fair trial.
All right, Mr. Steele, in terms of what I've told you all already, we're still going through the, I've told you all, both sides have told you. So this just delays the trial. I mean, where I've got to rule upon other things.
Well, I made this motion whenever I made it, and I raised it, and you said we'll get to it.
Yeah, but it's timing. I mean, did you raise it when we first got in here this afternoon? Did you raise it yesterday? Did you raise it kind of so I could kind of take it at that point in time? None of you did.
If I would have been told that there were going to be 3 additional jail calls, I could have raised it. The 2 others are already in. I didn't object.
All right. Okay. All right. Ms. Love?
Your Honor, just the state would ask that the court deny the motion for mistrial. The state has provided to the defense these jail calls. We have actually requested more than once what portions are objectionable, what portions do they not want us to play. We have sent them to the defense in a format that they can listen to them offline without having to have the actual CD in. We have had them converted for them. The objection that we got initially was put to the call that Mr. Steele essentially put in by playing the recording of the interview that Detective Quinn did with Adrian Bean. And the whole jail recording that was played during that interview was State's Exhibit 175 Charlie Alpha. So the portion that they initially said that they objected to, that third party portion, and we had a motion on it, they actually introduced by playing the call, the interview with Detective Quinn. I have said to them, I'm certain that Ms. Hilton has communicated with them via email that we are using the jail calls. And I know I personally have asked, what do you object to? So at this point, I'm not certain why there is this motion. I object to the language that is used. I'll die if the court does this. Your Honor, the court is well aware of the times that the state has received reprimand, both in front of and out of the presence of the jury. I'm not certain where that's coming from. I would ask that the court, of course, the court has already ruled, but the notion that there is a bias, I'm not certain even where that's coming from, given the amount of tongue lashings we've received from the court on the state side. So I would just object to the defendant being granted a mistrial. And I state for the record that the portion that they identified for us that they objected to regarding the jail calls was entered through their cross-examination of the witness, Adrian Bean. Thank you.
What about the sealed document Mr. Steele is raised or made an issue of at this point?
With relation to the sealed document, that was a memorandum of the interaction that a lieutenant with the district attorney's office had with a party as it relates to Mr. Steele's interaction with that party, unsolicited, after walking out from the stand. That party made comments to members of the district attorney's office. The state asked that party, and we did not assume facts that were not in evidence. We asked, unlike the question, why did you do this? Or why did you do that? Which would assume facts that were not in evidence. We asked the open-ended question with a good faith basis for doing so, and with an ability to impeach if there was a denial of having said it. So we didn't make that up out of whole cloth. We wanted to make certain that all parties on the defense side had that random. And frankly, Your Honor, I think it is improper for anyone, for certainly any member of the bar, to stand up during the cross-examination, direct examination, and offer testimony essentially to a jury. So for Mr. Steele to stand up in the middle of my redirect of Adrian B. and to say that did not occur, or preposterous or outlandish, is completely improper, disrespectful. The state has done nothing of the sort. And we would ask that Mr. Steele be reprimanded for doing so, and the court rightly did so. And to have him ask for an apology after he has been blatantly, improperly acting before the jury, I don't know what else I could say. I would just ask that the court admonish counsel for testifying during trial. I have given the state, the court, the basis for the questions that I've asked, and I've never asked a question that assumes facts that are not in evidence. Unlike the question, why did you know that? Do you recall that? I didn't phrase my questions like that because I know not to do that, and I'm not gonna do that. And I don't want to improperly give the jury an impression of something that exists or that will be shown that I can't show them. So there is a real clear distinction in what Mr. Steele asked, implying, why did you give a statement at the hospital? And he keeps conflating what it is that is objectionable. He keeps asserting something so that everybody in the ethos is asking, oh, where is this interview? Where's this recording? He's never seen one. He doesn't have a good faith basis asking for one. And yet he continues to put that question out there so that everyone in the universe has this idea, oh, the state is hiding something. Oh, the state destroyed evidence. Again, they sat there for a whole day asking witnesses about the destruction of evidence. There was no evidence that anybody destroyed any evidence, yet they stood there a whole day and asked someone about that. And then he asks a witness on the stand under the guise of impeaching him, do you recall that? Or didn't this happen? Or can you explain why the state would delete, or can you explain why the state failed to record your interview at the hospital? And he has no information that an interview at the hospital exists. So all of that, Your Honor, I don't know if Mr. Steele wants, to give an impression. I don't know. He's vigorously advocating for his client. That's what he is supposed to do. But I would ask that the court deny all of his motions. They are baseless. And I would ask, I've taken my licks from the court. We all have. And I'd ask that the court deny the motion for recusal. The court has made rulings that obviously the state hasn't agreed with. The court has made rulings that other people haven't agreed with. So this notion that somehow the court is biased, when as recently as a few days ago, I caught it hardest. It was played everywhere. I'd ask that the court just deny Mr. Steele's motions, all of them, out of hand.
All right. Ms. Hilton, do you have any explanation as to why this third call was just disclosed today? Is that true? Is Mr. Steele correct?
No, he is not, Your Honor. These calls have been turned over. As a matter of fact, I'm getting ready to send an email to defense counsel that shows when they asked us to have the calls converted because they could not hear it on a CD, they asked us to have these calls converted. Literally on January 5th, and I'm actually in the process of forwarding these calls. Mr. Smith sent these calls on January 5th, all of them. I believe a few weeks ago, this is the email that I'm looking for, when this case was first going to happen, probably in December, when we were to disclose to defense counsel what media we were going to use. I believe in one of those emails, and that is what I am looking for, I told defense counsel we're going to use all of the jail recordings. So this is not a surprise to them that we're using the jail calls. The only call that has ever been objected to is the first call that was played yesterday. They have not made an objection to any call. Now, they just want to know which of the 8 calls this is, then the state has no problem to do that. But to say that they just received the calls or they just learned about the calls, that is not true. They've known about the calls. Now, for me to identify this last call, I can do that. And I'm going to look for the email, or it might have been conversation in court. But when they ask, what media will we use? I think I said, we're going to use all the jail calls. And we're not actually using all the jail calls. We're going to use 5 of them. So this is not new evidence for defense counsel.
May I respond?
Sir.
About and maybe this will give a path moving forward that's a little bit more efficient, hopefully. There are thousands of jail calls in this case. So,
Your Honor,
hold on.
not for this case, for Acts 5 to 7 specifically.
Okay, there are thousands of jail calls for this case. So they gave about 10, 12, however many jail calls. They're saying, I'm not going to dispute that. I don't have my computer in front of me. But it seems very inefficient to me that we're going to litigate, and you want us, the defense, to raise our objections to thousands or even 12 jail calls and suggest redactions for all these jail calls.
But when did you get the jail calls? When did they tell you? Didn't they tell you like within a week or two, like I asked before, that they were going to use these calls?
So, Your Honor, they just identified one as the chicken call. That's not how they are in discovery. So there's a cross-reference number. So we need to know exactly what call by the cross-reference number in discovery. There's nothing labeled chicken call. There's nothing.
All right, but listen, is there a certain number of calls for this particular type, for this particular act or acts? Yes or no?
I can't. I don't have the email in front of me. So
yes. Okay. So there's how many? 8, 10 calls? How many?
Your Honor, there's actually 8 calls, and 2 of them were duplicates. And so in the email that I broke down
So in preparation, you know that if this particular act, which we've been dealing with for weeks, you only got about 12 calls to listen to, right?
So yes. So you would like us to proactively state our objections for every call and litigate, because they're not using every call.
Only if it becomes an issue, because if you all work it out, that's fine. I don't have any issue with that. But if it's going to be an issue, then I need to be able to vet it. I got to listen to the call. I got to listen to the evidentiary basis as to why it should be admitted or not admitted. That just gives me time to do that. And if you say it's only going to take about 15 minutes or whatever, well, it may take longer than that. You see how long we've been out dealing with this issue. So that's what I mean by forewarned judge is a happy judge. So if we could take it up and I don't have to either have them sit in their headquarters, it's better for all of you.
I do not dispute anything you're saying, Your Honor. All I'm doing is suggesting that if last night or yesterday we were told tomorrow we plan on playing this call and it wasn't the chicken call or the whatever call, it was whatever the number is in the discovery or on the email, then we would certainly, I would say it would be on us. But that's not exactly what happened. I just want you on, and I'm not trying to, I really like Ms. Hilton a lot, so I'm not even trying to argue with her or say she's done anything wrong. It's just, I think if we know a little bit in advance, and it's not just, the chicken call, then we would be in a better position to lodge our objections to you. Because right now they are, I assume they're getting the cross-reference numbers, so then I can bring those numbers to the defense table so we can pull up the exact calls that they want us to review. So that's kind of, I just wanted Your Honor to understand it's not as simple as just we didn't listen to the chicken call.
Your Honor, if I may respond briefly, Mr. Williams, I believe, filed a motion in limine number 40. That was the only motion in limine that we had as it related to a jail call. And that was objecting to the third party information contained in jail call number 175, Charlie Alpha, again, that Mr. Steele introduced by playing the interview of Detective Quinn conducted with Adrian B. So we have again turned over the 8. We can specifically give track 1, 2, 3, 4, or 5 of CD 1, 2, or 3. We can give that information to them. The way that Ms. Hilton and Atkins noted and time hacked each of these calls references specific information in the call. That is the only reason Ms. Hilton identified it as such. But there were 8 calls. There is no other call within which the information she has spoken to the court and described the call using. There's no other call that has that information out of the only 8. So I'm not certain the reason for the reference to thousands of jail calls in this particular context. But, Your Honor, we have 8 jail calls here. We've turned over. We've asked, what do you object to? And the only thing that we've gotten was motion limiting number 40 from defendant Williams.
All right. Anything else before we recess? I still got to allow you to listen to the phone calls.
The facts got lost. The accurate facts, I've listened to all the calls, the relevant calls. I've listened to them all. I know what the chicken call is. I know what the baseball call is. The issue is there's third parties making statements of fact, introducing statement of fact. We argued this. The state's position was it's non-hearsay because it goes to the effect of Mr. Bean, who will be a witness. I dispute that. I believe it's hearsay. That was the issue.
Yes.
You said, we'll take it up.
Yeah.
That's it. I'm not saying I don't understand the parameters. The only call that's at issue is Madam President, District Attorney Hilton said, I don't remember what the third call is. I'll let you know on a break. I was comfortable with that. But I just want you, before these jail calls are being played, to make a ruling, because I waive it.
I need to
whether
hear,
it's
I need to
hearsay or
hear the
not.
call, though.
Exactly.
Okay.
That's
All right.
what, that was my objection. That was it. And I did it in a manner that I thought was appropriate to say that we raised it. Your Honorable Court told me to let you know. And then we got here.
All right. All right, N105? Yes, sir. Okay, all right, they're both denied. I'll note your objection and the continuing objection, Mr. Harvey. All right, we're gonna take, did you have something, sir? Okay, we're gonna take 15 minutes so you can listen to the call, and we'll come back at that point in time, okay? All right, we're in recess.
So y'all see how crazy it is. It's absolutely asinine. But we've been here 3 hours, so I think I'm going to get ready to bring us to a close. I greatly appreciate all 6 of you guys for staying in here with me. Anytime anybody might have an issue that they want to talk about, especially if it's about, our condition, our people, our way of thinking, our parenting. If you just want to chop it up, please feel free to say it in the chat, and I'll, drop the link if you would like to say something, because we're in a crisis as a people. And I believe in one race, and that's the human race. And I believe that we're all separated by our statuses. And I believe that the masses are considered the have-nots. So it doesn't matter your hue, your nation, your hairline, lace front, or Becky Lou Curly's. It doesn't matter. We're all in this together. And we all have not been taught everything we need to know. Some has been taught more than others. But we're all pretty much at a deficit when it comes to the politics that's being played right before our eyes. I oftentimes talk in my private and personal conversations, we grew up on marbles and jacks. And our European counterparts grew up on the game of life and Monopoly. And they have a better understanding and concept of what's going on. We have not a clue. And it's time for us to get a clue. Because if you're anything like me, you're a baby boomer. And we don't know at no point in time when any of us are going to leave this plane and go to the next. But it would be wise of us to learn as much as we can and teach it to our babies. Because one thing I know for sure, if you don't know where you came from, you're bound to end up in the same place. Because life is a circle. And it goes around and round. So we need to learn to do something different. We need all ages and all stages of life, no matter what your condition, your situation. Everybody's voice matters. And it needs to be heard. If you haven't considered it, consider a YouTube page. I don't know everything there is to know about YouTube. A lot of things I don't even want to know, but some things I'm going to have to learn. And some of you guys are very talented, very gifted, very. So I would suggest that, we all become a part of something great. We might not be able to be on the front line and march and fight and overcome in that manner. But we have the ability to think, we can talk, we can write, we can encourage. Sometimes if we encourage somebody else, it may encourage us right on out of our depression. Because a lot of us are depressed. And it doesn't matter that you can pay your bills today. Maybe tomorrow. Who knows when life will change? Because sometimes it changes in an instant. And I like real issues. So I'm, I don't have no regrets of not being the comedian of YouTube and not doxing everybody that's on here and mistreating people. I didn't come here for that. I came here to help uplift and to share me, and that's what I do on Wednesdays and Sundays. And lately I've been doing little shorts. And I want to thank everybody who subscribed to my channel, whether you come or not, or drop by. I greatly appreciate you. Please consider subscribing, hit the like button, and consider becoming a member. It really helps. Regina said, I have to respectfully disagree. We, the people of the USA, are not in it together as one. If that was the reality, we would have to always been considered equal, and that is not the case. Oh yeah, that's true. I agree with that as well. Two things can be true at the same time. So I don't have no problem with that, and we can even disagree. I don't have no problem with that. Life is what it is. But I'm like chocolate soup. We all in this together. May as well make it work. That's the old group, and they got a nice song. And we all in this together, whether we on the same side or not. And so we may as well make it work. That's my philosophy. And that's what it is. So, on that note, as y'all know, I believe the children are our future, and we got to teach them. If anybody have any ideas or anything, of course, I'm going to be covering this trial, but I wanted y'all to see some of the things that has taken place that Mr. Steele put in his motion to show the judge what's been going on, and she wrote all of that out of her motion when she recused him. So she wrote all the misconduct out. So this has to keep going, and I believe it's going because of Orca. That $75 million that's going to run out at the end of 2024, and they want to milk every penny of it. Of course, the people are not seeing it because people are still in Fulton County Jail, unindicted, haven't seen an attorney, and some still being unalived. So, you be the judge. But I would ask everybody to please start reading the Constitution. Learn the 7 articles. You don't have to memorize them, just learn them. The first 10 amendments are your Bill of Rights. And you can go all the way up. I think they go to 26 or something like that. But they keep violating our first, our fourth, our fifth, our sixth, our seventh, our eighth, and our 14th due process amendments. The motion for a mistrial was submitted this week. What are your thoughts on how soon a ruling? I don't know, Regina. With the way they keep changing judges, I'm going to say, if this judge decides to stay and not recuse herself, I'm going to say they're probably going to have a decision next week. Because, they still have the jury that has not been dismissed, that's been out for 30 days. They've been out for over 30 days, actually. And then they're telling them, the instruction was they can't listen to any of this. They can't talk to anybody about it. And they've already been there 18 months. There's nowhere in Sam Houston that they haven't found out something about this case. So I think that it's going to be coming up soon. They're going to be asking also for bond for those guys. I think they need to forget about the bond. Now, I'm not saying the lawyers should forget. I think they should ask. But I'm talking about whoever this jurist is that's going to make this decision needs to make this decision with prejudice. Because, again, with Rico, the crime's supposed to be within the last 4 years. They've already broke that when they keep going back to, Mr. Thomas unaliving, and then things that they did in 14 and 13 and 12 and 10. 20 I'm talking about. 2010, 2013, 2012, 2014. We're in 2024. This trial started in 2023. Rico is supposed to cover the last 4 years. Most things have a statute of limitation. And they've gone too far. But I'm thinking that it's going to be soon if this judge decides to stay on the case. The question is, will she go on and do the right thing that her colleague didn't do? And that was to look at this case in its totality and grant a mistrial or a dismissal with prejudice. It doesn't make sense. Nothing that they are claiming have come to pass, not even close. And then the only thing that they said they need to build their case on is a gentleman who says openly that he lied about everything. And he doesn't mean that he doesn't ever tell the truth, because you can tell he's hurting. You can tell he's human. He has pain. He's misguided, like most of the children are misguided. I can't see the new judge will continue with this trial and start over from the beginning all the way back to 2022. That would be lunacy. I agree with that, Regina, 100%. It took them almost 10 months to pick a jury. And that's because Love was doing all of her shenanigans, and, Glanville was letting her. Biasville, he was letting her. And everybody seems to owe everybody a favor of some sort. And that's how it goes in that world. The world that's above us. Which nobody is above the law. So we got to stop these political gangbangers. We got to stop them. The gatekeepers. We got to stop them. And the way we stop them is with knowledge. And then exercising our rights. That's how we stop them. We don't have the weaponry to stop anybody. You can own all of what the Second Amendment give you, all in your life, but you don't have lasers. You don't have the equipment that they have, or they have access to. So that's not even a thought. Strategic thinking, critical thinking, and action, writing, petition. First Amendment gives us the right to petition our supposed government. We need to petition them as a people. You can pick any candidate in the world you want to choose. I don't have anything to do with that, but I would ask you to get involved in your local elections, because those are the people that end up like those people in Fulton County. There's no way people that look like me, Asiatic, should have such disarray. We all love to talk about how we built this country. We didn't build it on ignorance. And we didn't go to nobody's school. We relied on what's inside of us. And that's what we got to do, is go back inside of us. Where are you in your mind? Dig deep. The answer lies within. And on that note, I'm leaving the Tiger's Den. Thank you guys so much. I appreciate you all. I believe the children are our future. Teach them well and let them lead the way. Show them all the beauty they possess inside. Give them a sense of pride to make it easier. Let the children's laughter remind us who we used to be. Everybody's searching for a hero. People need someone to look up to. I never found anyone to fulfill my needs. A lonely place to be. So I learned to depend on me. I decided long ago never to walk in anyone's shadow. If I failed, if I succeed, at least I'll live as I believe. No matter what they take from me, they can't take away my dignity, because the greatest love of all is happening to me. I found the greatest love of all inside of me. The greatest love of all is easy to achieve. Learning to love yourself is the greatest love of all. And if by chance that special place that you've been dreaming of takes you to a lonely place, find yourself in love.